sir. If you could each please raise your right hand. Do each of you solemnly swear or affirm the testimony that you're about to give in this cause shall be the truth, the whole truth, and nothing but the truth, so help you God? Okay, who's going to be first?
Steve Moninger.
Mr. Moninger, you can have a seat up here on the witness stand. The rest of you, the rule has been invoked. There is a standing order with regards to that. If you could please wait outside. Mr. Garcia, I'll have to admonish you further before you testify this afternoon.
Ms. Monica, when you speak, make sure you get right up close on that mic.
Chris.
It'd be right up.
Chris.
Right up on the phone.
Yes.
What's going on?
We were able to procure immunity for Mark Garcia. The immunity agreement's been signed. Behind it, you'll find a sleeve that has a disc. The disc has the copy of the transcript of an interview between Mark Garcia and the FBI and Rangers. And then there's actually a hard copy of the transcript as well. But there's also a video. There's a place for your signature on page 4. And additionally, we met with Mr. Garcia and his attorney last night, and we had several hours of conversation with him. We learned more information. We're going to need to do a supplemental proffer based on that because it is not included in the interview. Therefore, we would ask for more time to accomplish that for proper notice to the defense.
Well, we intended to reset for the defense to prepare their punishment and cross-examination, so that needs to be tendered to them. I'll figure out when we're going to come back, and then I'll give you a date certain that has to be tendered to them.
And then can we do directing?
In writing.
I'm sorry?
In writing, you will have to tender
Absolutely.
it in writing.
Yes, that's what we would like to, if we get accomplished with the 4 witnesses this morning, we would like to have him in our office this afternoon to finish that, and we'll get it done as soon as possible. However, we would like his direct and his cross to occur after that and all at one time, no break. Therefore, no transcript would need to be ordered, and therefore memories would be fresher about what's done on direct and cross. And I think for purposes of defense counsel, for him to properly object, he will need to know what is coming. I don't know if you
Well,
agree with him.
we can cross that bridge in a little bit. For now, I want to get through these 4 witnesses.
Sure.
So, is there anything that you want to add to that, Jason?
No.
You've tendered a copy to the defense?
No, I was going to wait for your signature. We need your signature first,
Okay.
and then we'll tender cover.
I'd like to read it before you sign it.
That's fine. Read it. Go ahead. We have further witnesses.
Also, have you made a decision on the news broadcasts?
Not fully, but I'm very close. So maybe before the lunch break.
Okay.
Well, Your Honor, I mean, I think that, you know, if you remember, the state, they said the reason they needed that was so that they could prove what they couldn't prove without Mark Garcia. And as if they have him now and they're doing this proffer and everything else, I'd like you to hold off until he testifies, because I think it would be, I think that all the probative value of that starts to become way lower, and the prejudicial effect starts to become way higher on these news broadcasts and these other things. And so, especially if it's cumulative of what the testimony they're now expecting to have from Mr. Garcia.
Well, the only one that I would be interested with anything that Ms. Barrientes Vela said at the press conference. I'm not really interested in anything else. I think that's relevant. And authenticity is there because it's from news agencies that have an FCC license, so the authenticity is there. But we need to talk about relevance. I do believe her statements are relevant. So maybe you guys can start working on a redacted copy. But I want to fully address that after these witnesses, and I don't want to keep the witnesses waiting any longer. So take some time and read that.
Additionally, regarding the proffer, the supplemental proffer, we were going to limit it to the Moreno arrest relating to the act perjury and the official oppression, unlawful arrest. We weren't going to go into other matters that he does have knowledge of, but we were going to limit it to that. If
That's what I intend to limit you to.
okay.
So.
All right. Okay.
All right, let's get going with these witnesses, please. Jason, is there someone that can be looking at that while you handle this? Is there anyone that can come?
I'm sorry.
All right, let's get going.
But I can look at it after the witnesses go through.
That's fine. Go ahead. State, you may proceed.
State of this time, call Steve Mocker, please.
How do you spell your last name?
Moninger.
Thank you.
Mayor Procedure.
Yes.
Mr. Monaker, is that how you pronounce it? Okay, great. What do you do for a living?
I'm an attorney with the Department of Public Safety
And how long have you been an attorney with the Department of Public Safety?
since 2005, August 05, 17 years.
17 years?
Yes.
What did you do before that?
Civil attorney, contract, that sort of thing.
So you're fading.
I'm sorry.
As long as you can.
Okay. Is that about?
Yes.
Could you explain to the judge what the Private Security Act is in the Occupations Code?
It is the enabling statute for the program that regulates the private security industry in Texas.
And could you explain to the judge when a full-time officer paid by the county can perform off-duty security work?
Full-time officer, they can work off-duty, part-time work. Full-time being defined by the statute is 32 hours with benefits and such. If they work directly with the client, for the client, or for a private security company, they can work part-time off-duty.
Okay, so there's two ways that a relationship for an off-duty job can happen. That first is, you said directly with the client. What do you mean by that?
Say they work at a grocery store or a convenience store or something, and the owner of the store pays them directly. Maybe they work for a private security company.
And how does one become a private security company?
One applies with us, background checks, fees, and they have to have, the owner has to have a certain amount of experience in the industry. And for purposes of a guard company, for instance, I believe it's 2 years of the prior experience. And then any contract that in the industry has to be through a company, so individuals cannot be employed directly with the client, except in this situation we're talking about an exempt peace officer.
Okay. And what about when can reserves perform off-duty security work?
Well, they are specifically exempt from, they're exempt from the exemption, the one that applies to peace officers. It specifically says this does not apply to reserves. So the only way they can do that is if they get a license with us as a commissioned security officer, and then they can work for a company or a license as a company themselves. Of course, they can do that.
And so without that license as a security officer, what type of side jobs could a reserve do?
Well, it kind of depends on what we mean by side jobs, but if the county or the city has a contract to perform services, to provide security services, such as for the rodeo or something like that, or a church, for parking, that kind of thing. If it's a traffic issue and the city decides they really want to regulate that, as long as the reserve officers are paid by their employing agency, the municipality or the county, then it's considered, what's the word I'm looking for? They're providing professional duties for the employer. So if that's not the case, if they're paid directly by, say, the convenience store or the church or the rodeo or whatever, then they need the license.
talking about that relationship between the client and the security officer, does that mean that the money has to flow directly between the two parties?
Yes, I mean, that's our general way of interpreting it. Yes, it has to, the paycheck has to show that they were paid by the employing agency. And similarly, if it's an exemption for a full-time peace officer who is exempt and doing part-time work, it has to be paid directly as opposed to being paid, say, by another individual. Somebody who should be a private security company but isn't, for instance.
Okay. So functionally, there should be no middle person.
That's right.
That's what it is.
Okay. Mr. Moninger or Moninger?
Moninger.
I'm Jason Garcia. I had the pleasure of practicing DPS law, where I guess I feel good. But let me ask you some questions first. Do you play poker? Have you ever played with your friends?
I have, but I'm not any good.
Yeah, that's okay.
Jason, can you put one of the microphones close to you, please?
Oh, yes.
I can't hear you.
Yeah, I'm sorry. It's the morning. My voice hasn't warmed up yet. And the reason I ask it is because you know that there's separate laws in Texas that say if you're playing poker with your friends at night and y'all can put money in the pot and everything else, as long as the house isn't taking a cut, it's okay. That's okay to do. It's not illegal to have a poker night with your friends, and you understand that.
Yes.
And the reason why is because if the house is taking a cut, all of a sudden that becomes a gambling establishment where the house is profiting off of gambling being done in the establishment. And if gambling isn't legal, then that would be an illegal gambling establishment, right?
Sure.
Okay. And so I want to talk about, because one of the things you said is you said our general way of understanding it. So you talk about when we're talking about the statute. Is it your opinion? I guess they proffered you as, I guess, an expert on this statute. Well, that's the only way you can talk about it, is to be an expert on this because they've asked them those questions about it. So I want to ask you questions about the statute in particular. Is it your opinion that the reason for this statute was to regulate law enforcement agencies who had their officers working, their full-time officers working security jobs?
I would say that was the primary purpose of the legislation. No, I think it was to regulate an unregulated market.
Right, like people who are like, armed up and then they're going out to protect a bar or something and they don't have a license.
That's right.
And because in this situation, you talked about the general way of understanding it, but I'd like to present some of the facts that were presented at trial. So first of all, it was presented at trial that in this particular situation, the agency, the constable's agency, is not taking like a percentage of the people's work. They are taking the money from the customer and giving it to the officer in an envelope who's working the thing. And I understand that you say, well, that's, I guess, maybe technically in your general way of understanding it, a violation of the statute. But in this particular situation, what was happening was that the officers would go to the place where they were supposed to be security, and the people there were refusing to pay it at the scene. Now, there's also, I don't know if you know this, I don't know if they told you, but there's also rules and regulations, and we're talking specifically about a park. And a park has pavilions, and it belongs to Bexar County, and people rent out the pavilions. But if they have alcohol or more than 50 people, they're required to have security from Precinct 2 Constable's office, and they're required to pay for it. Okay? So taking those facts, what was happening and what the testimony was from their witness was that the officers would get to the scene, and then the people would refuse to pay them, which would then put them in a situation where the officers would either have to work without getting paid, or the pavilion would be unsecured. You understand that?
Sure. Yeah.
Okay. And so, do you believe that the statute contemplated instead the constable's office saying, well, hold on, come and pay beforehand so we know that it's paid before we send an officer out to the scene so they're not getting in a conflict with these customers out at the time? Do you think that this statute that we're talking about was written to prevent somebody doing that, to try to have a more, I guess, orderly, an orderly situation as far as security at the park?
Well, personally, I think it's a bit of a stretch to think that the legislature contemplated any of that in '72 when they wrote this very basic statute. But I think there is language that specifically says if you are performing official duties so long as you're compensated by the employing agency. The question is whether that's applicable here or not.
So you would consider that still an open question about whether or not the government agency who takes the money and then gives the money to them is paying them, which would be an exception.
Well, no, on its face. I just don't know exactly what the details are about that arrangement.
And I guess have you had any experience, I guess, I don't know if I'd say prosecuting, but like suing under this statute?
I'm trying to think of, I mean, suing as in for, what do you have in mind?
Well, yeah, because I don't necessarily know how y'all would do it, like enforcing this statute.
Oh, certainly.
Okay. And have you ever enforced it against any law enforcement agency themselves, like an actual law enforcement agency?
Yes.
Okay, and which law enforcement agency?
It was, I can think of one particular case. It was the constable's office that was running a private security company out of its office.
Was the constable taking the money for it?
Yes.
The house was taking a cut?
Yes.
Okay. So that is different, I guess, if the facts that I'm giving you is that the house is taking no cut. It's just come here first a week before so that we don't have officers getting in a fight with you at the scene. And then they give them, it's a pass-through. They give the money directly to them.
I think there's a way in which that could be done, so long as the money was clearly identified as the agency, the employing agency's money or the county's money, going to the officers and not directly from the park participants.
Well, but I guess that's a conundrum then that I want to talk to you about. Because what you're also saying, though, is that the right way to do it is for them to go and get it directly from the participants. We're not talking about reserves. We're talking about full-time officers who are exempt and who can do security. So you're saying on one hand that the right way to do it is to go get it directly from them.
Oh, no, I'm sorry. I was speaking of two different types of officers. I mean, for the reserves, the only way they could do this without a license would be if they were paid. And then
Sure.
With respect to the full-time officers, they are exempt only if they are paid directly by the client.
Okay, so, and maybe that was my fault for the confusion.
No, I mean, it's confusing.
You're right. It is confusing. And I'm talking about the full-time. Okay, so these are people that are exempt. And you're saying the only way to do it is to get paid by the person, right?
Well, no, they would be in the same position as the reserves in terms of in terms of performing official duties. Were they paid directly, paid indirectly, paid by the county or the constable's office, then they are also not required to have a license in that case. So they get the benefit of the same provisions that apply to reserves.
So if the constable's office is accepting the money for the security and giving it directly to the people, and the constable's office is paying, are you saying they're exempt from the Private Security Act?
If that money is flowing from the county to them, yes. But again, I'm not sure that I can really speak to the details of the compensation arrangement. If it's cash that goes from one hand to another, it's a little bit more difficult to say that that's the county's money. But there's an argument. We're dealing with vague statutory language that has to be applied to specifics, and that's the only reason I was a little fuzzy on my original statement.
I understand, and honestly, I don't have any issue with what you're testifying about. Because I agree with you. So because it's vague, and because you have what I've heard you say is vague. I've heard you say arguable. I've heard you say that the situation seems like it is not a clear-cut situation.
And I'm saying that because I don't know the details of this case.
Okay, and so and that's why I'm posing some of these. You know, like I said, I'm telling you these things that have been testified to.
Okay.
And you can assume them as true as part of the hypothetical.
Sure.
So the full-time deputies at one time were going to the park and getting the money directly from the park. And then the park people started refusing, or there were times they would refuse to pay, which would put the deputies in the situation of either working for free or leaving the park unsecured. They either have to stay there and be the security if the people are refusing to pay, or they have to leave the park, and the ordinance and the requirements are that they have security, but it was allowing these people to just welch on their debt, right? So that's the situation that's arisen. So then a policy at the constable's office is a week before your customer, a week before when you've rented security, when you rented the pavilion and need security, you come into the constable's office and you pay for your security. And then that money goes to the officer who is providing the security from the constable's office. So in that situation, is that the kind of situation? The constables keeps no money, they don't profit off of this. The only people that get the money are the officers working the security. So instead of having to go the day of the security and try to wrangle with the customer and fight with the customer there about whether or not they'll pay, they have it orderly done a week beforehand. Does that make sense what I'm saying?
Yeah, I think so.
And do you see why that having them come in there and know a week beforehand whether the officer is going to be paid for the security has some value as far as making sure officers don't appear and fight with them at the scene?
Okay, and I think fundamentally we're talking about whether or not that qualifies as official duties. I think that's what the phrase we're looking to interpret.
Okay.
Are they being paid by the employing agency to perform official duties? And I can't answer that. I'm just a guy that has been trying to figure that statute out for a while, enforcing it against regulated people and advising prosecutors occasionally on what we think. But ultimately, we fall back on this is something for the courts to figure out and for the prosecutors to argue. In a specific case like this, I don't feel like I can really say, yes, that's a violation of the law. I think you've got to flesh out what that phrase means in this context. It's a little complicated, the scenario you've described, so I'm not going to say, yes, absolutely, I would call the DA and say, you got to go after this person, but there's an argument for it. So.
Sure, and I think that's been my ultimate point since August 22nd, which is if it's hard for you to figure that out, which is somebody who has dealt with this statute, and there's nothing wrong with it being hard. I understand. I'm a lawyer too. I know that a lot of times statutes are difficult. Sometimes only judges or juries or appellate courts will tell us what that means. But if it's hard for you, would you agree that then a kind of a strict liability where somebody is being held as like you have violated this statute would be unfair under those circumstances because it's arguable both ways?
In practice, that's the sort of thing that we would bring up and discuss with a counsel representing that party and discuss it. And if we felt strongly about our interpretation, we might ask for an AG opinion, or we might, something like that. But and often, they would just agree to change their procedure to make it more explicitly above board.
Coming through the county, more explicit that it's coming directly from the county. Because if it's coming through the county, if the money can be said to be coming through the county agency to the officer, that's completely fine.
Right.
And so that whatever the ambiguity is, I guess the strategy would be to just talk about it and see about ways that you can solve the ambiguity to work that out to where it's
right.
Because ultimately, a constable's office that's not taking a cut of the money, that's really just trying to make an orderly transition of the money to the officer so that the security can be done, that is not high on your list of priorities of things that need to be dealt with in criminal.
That's fair.
And So ultimately, I guess ultimately we could say that the scenario as I've described it is, the scenario as I've described it is, in your opinion, murky or ambiguous as far as whether or not it's a true violation of that statute?
Yeah, I think I have to say that.
Okay. Your Honor, that's what.
Let's talk about some other scenarios, and specifically with reserves. So suppose that there was an individual who wanted security at a park, particularly a pavilion. They went and paid money at the constable's office for security at that pavilion. At that point, the constable's office assigned a reserve deputy to work security at that park. And subsequently, that reserve deputy was not paid by the constable's office. Would that be a violation of the Private Security Act?
Well, whether he's compensated or not, it seems like that would be an issue between him and the office. But if the theory was that he was to be compensated, I mean, that's really what we're talking about, the legality of the arrangement, then that would be okay because it would be official duties. He's being paid by the employing agency to perform security. There's an arrangement presumably between the county and the constable's office to do that. So, again, that would be official duties. Sure.
And if security at the park does not fall within the purview of official duties of the constable's office, does that change your opinion?
Yes, but I think it depends on how we get there. I mean, the phrase is not defined in the statute. It's going to have to be looking at the public documents, the contracts and such arrangements, but and generally, as a matter of practice, we defer to the agency. We're not going to dig into that unless it's a major to do.
What type of paperwork should be associated with the...
I'm just talking about contracts or, city council memoranda, whatever that would assign.
So if the county listed that security at parks is not part of the official duties of a constable's office, that would
be a pretty strong
indication that
it's not. Yes.
So the key phrase is whether that person is doing official duties for the office.
I think so, sure. I mean, yes.
Absolutely.
Mr. Monaghan, can you tell us whereabouts, and I don't hold you exact date, but when you were contacted by the state of Texas to testify?
It seems like a long time ago. I want to say it was spring. Maybe, was it April? April or May.
Of this year?
Yes.
You weren't contacted 2021, 2020, as far as...
I don't believe so.
Okay. You spoke about a particular case involving a constable's office that was in violation of the Private Security Act. What were the facts of that case?
Well, it's been some time. I want to say 10, 12 years, but my recollection was that, it had all the trappings of a private security guard company in the sense of employing the constable was using his reserves and other officers to perform personal security contracts that he had established, just private businesses, that sort of thing. And
like at churches, other places, just kind of random?
Yes, things like that, but also, nothing that was colorably public in any way. Nothing with traffic, that kind of thing. There's more blatant private security in hardware stores and things like that.
And was assigning reserve deputies?
That's my recollection, yes.
And was this constable taking a portion of the money?
Yes, that was the evidence that he was pocketing the money, and Again, I don't remember too many details, but, and we didn't do anything with it. This was the local prosecuting agencies that did it, but I was involved in helping out with figuring out, for instance, who was licensed, who wasn't, whether they used this.
Kim, in that case, assigning reserve deputies to perform security, was this person pocketing all the money from reserve deputies or just a portion?
I don't recall, but, yeah, sorry.
That's what
I guess you said nothing that was colorably public. So in this case, we're talking about a public park that's, I guess, run and operated, theoretically owned by Bexar County, belongs to Bexar County. And when a constable comes on duty, I guess when a constable is elected, Bexar County tells them it's their responsibility to provide security for that park in their jurisdiction. In that would be different than the case that you're describing.
Sure.
Okay. Because that would be a colorably public duty that we're talking about.
Yeah, that's what I meant by that phrase.
Sure, you're talking about like private hardware stores, like private Walmart, or whatever, and then with the constable actually pocketing the money that was, some of the money at least, profiting off of the work of the other officers, which that's what a business does.
Right.
Rather than, I guess, rather than a pass-through or a way of orderly, in an orderly way trying to give money to the officers who are working with security. So that's different. That's not what he was doing in that case.
No.
All right. I'll pass it.
no further questions.
Thank you, step down and be excused.
You may be
Thank you, Mr. Monitor. We appreciate your time. Our next witness.
State calls Renee Garza.
As far as you were sworn, you remain under the same oath.
Yes, ma'am.
You may proceed.
Thank you, Your Honor. Could you please state your name for the record?
Renee Garza,
And how are you employed?
Justice Court Manager at Precinct 2,
And how long have you been doing that job?
since 2019.
What does that job entail?
I oversee the dockets for Judge Vasquez. I handle personnel issues. I do budgeting, administrative stuff for the office.
And what did you do before that?
I was a lead court clerk
And how long did you do that?
from 2011 to 2019, so 8 years.
And based on your experience and knowledge, would you say that you are very familiar with the computer system that operates the office?
Yes.
And were you asked to be a custodian of records for certain records for this case?
Yes.
the next exhibit number?
128.
I'm going to hand you what's marked as State's Exhibit 128. Do you recognize that?
Yes, ma'am.
And what is that?
It's an affidavit.
And who signed the affidavit?
I did.
And what is it for? What records is it for?
It is for the, if I'm correct, it's the affidavit for the warrants for being the custodian.
Okay, and how many pages are there?
It says 2,088.
And when did you sign this?
August 31st of 2021.
And did you produce those records to the district attorney's office?
Yes.
So, Your Honor, I don't want to go through form binder. I've prepared a summary of what is contained in here for your assistance. That summary is attachment A to the 3707 notice, but I do have a copy marked that I'll be handing you. This was also an agreement with defense counsel Patrick Valentine in order to make it much easier to follow on the 3707 notice.
So what is 128?
So 128 is the business records affidavit for
Okay.
these records.
And then what are you gonna, so all of those 2,000 pages are part of 128?
Yes.
Plus the summary is how long?
The summary is only 2 pages, but it lists all 93 warrants.
Okay, and it's also 128?
If you would like it to mark separately, that's,
Let's do 129 on the summary. And you're offering both?
yes, Your Honor.
Okay.
Well, under 1006, which governs summaries, requires the state to have it in court and for me to go through it all to make sure that the summary accurately reflects the.
It was previously tendered through discovery.
Right, but what is in the courtroom right now, I don't know what's being entered into evidence. I have to be able to check and see and match and make sure that it matches, the summary accurately reflects what's being offered.
All right, I'll give you a chance. You have a lot of work to do with me today.
I don't like that I do, but additionally, I will say that you have basically there's names of defendants and actually their personal information is on all of this that they're trying to offer into the public record. These are a lot of people in Bexar County that
Why do we need personal information?
These are downloads from the computer system for individuals that had outstanding warrants, and the constable's office executed on those warrants and had them pay fines and fees contrary to law.
I would not make these public. They would, first of all, the custodian would be David. If anybody wants copies of any of this, it's going to be sealed. They would need to get an order from me. But it will be made part of the record if I admit it. So your objections are noted.
I think that as far as the discussion, I think that I don't really have any. I guess what I'm trying to say is I don't have any opposition to the idea that yes, these were warrants and yes, they were paid in the way that they were. And we agree with that from these dates. So from February to April of 2017.
Lori, when this is going to be referencing any of these documents, or they're just going to be talking about what actions were taken related to these documents?
Actions taken.
Okay, we can keep going.
Okay.
I'll give them a chance to inspect.
Just so I don't have to bring these binders up to you, I'm going to hand you the summary. which is marked as State's Exhibit 129. And I just want to specifically point out on that summary, what is the first date that would be listed as the first warrant that would be in these binders? So I believe it's the executed date on the summary.
February 21st, 2017.
And then what is the last one, the date on that?
April 12th, 2017.
Okay. So were you involved in having to monitor the situation wherein this became an issue?
Yes.
And what was it that brought your attention to this issue?
The fact that defendants were having to pay prior to coming to see the judge when they had outstanding warrants.
And is that not procedure?
No.
What would be the proper procedure?
They are to, if they are arrested, they are to be brought before Judge Vasquez or a magistrate judge to be given options.
And did you receive any direction in order to accumulate all of these records to demonstrate how prolific of an issue it was?
Was given instructions to monitor the cases and to pull the cases and to make notes, yes.
And in whose direction were you following at that time?
At that time, it would be both Judge Vasquez and the previous court manager.
And do you recall when you began to investigate this situation?
Not the exact date.
Was it earlier than the April date that's listed on the summary?
Yes.
And as time was going by, was the issue trying to be addressed with the constable's office?
To my knowledge, yes.
But you weren't involved in that part?
No.
And what type of records did you accumulate in order to record that activity?
I would take screenshots of the summary page of our case management system and notate what occurred.
And how do you know what occurred?
Based on the events that are on the summary.
And so that's listed and somebody enters that information?
Yes.
And who would the individual be that enters that information?
It would be whoever was touching the case file at that particular time.
And would that be an officer with the constable's office?
It could be an officer, it could have been a clerk.
And there's two kinds of warrants here that we're talking about, correct?
Yes.
So could you state which each one is and the difference between them?
One is a warrant of arrest, meaning they have not entered a plea before the judge. And the second is a capias, meaning they have entered a plea and usually are given some sort of conditions to fulfill the case, to dispose of the case. And if they didn't, then they would have the capias issued.
So the first type, the warrant of arrest, would be something that's unadjudicated.
Correct.
And then the second type, the capias pro fine, would be that they have failed to follow through with the decision of the court.
Correct.
Both resulting in warrants.
Yes.
And that meant that the fines and fees were still outstanding on both types.
Correct.
And based on those notes that are in the system, can you tell what kind of activity was occurring with officers when reaching out to these defendants?
On some of the events, yes, you could.
And what, just as an example, what are some of the types of events?
How a warrant is executed, whether it was before the judge or...
When there's an objection, you have to.
Your will object to hearsay. Basically, when she's getting this knowledge through, I guess, phone conversations or something that she's had.
It's the same.
As a result of your investigation and collection of all these records, was there any kind of consequence that occurred to these particular cases that you recall?
Not sure what you're asking.
So after it was determined that there were 93 different warrants that were collected in this manner, what was the result of the final disposition of those cases?
There were convictions on the individual.
And the fines and fees that were collected from these individuals through the course of the activity of the officers, were those fines and fees remaining with the JP court?
Some of them were refunded back to the individual, so the fees and fines were eventually waived, if that's what you're asking.
Yes.
Yes. Okay, yes.
And why was that?
Because they were not given, they didn't have the chance to come before the judge.
And, well, I'll talk to the judge about that. Did you have any knowledge of the issue that occurred regarding security in the courtroom?
Yes.
And was there a particular issue where security was not provided to JP2?
Yes.
And what do you recall about that situation where security wasn't provided?
There were instances where they would not have any security at the front door.
The front door being the entrance to the JP?
Yes, the entrance to the building.
And what is your understanding on who is to provide security at the front entrance?
To my understanding, it was from the constable's office, is to provide security.
Do you recall how many times that occurred?
Not an exact number, but it was more than once.
And was alternate security procured?
As far as...
Because there was no security provided by the constable's
Yes.
office, did you have to get
Yes.
security? And how did you do that?
I believe Judge Vasquez contacted the sheriff's office.
So the Bexar County Sheriff's Office provided security?
Yes.
Are you aware of any other forms of security that were provided?
On occasions, there were court clerks of the not court clerks, I'm sorry, constable clerks that would be up there.
Clerks from the constable's office?
Yes.
They were manning security for the front?
If the officer was pulled from the door, yes.
Okay. Do you recall a metal detector being in place at the front entrance?
Yes.
Do you recall an instance where it was not there?
Yes.
And what do you recall about that?
I was told that it had been moved over to the constable's office.
Do you know who the metal detector belongs to?
It belongs to the JP court.
Do you recall if a third-party security company had to be hired for security?
I believe there was one day where, I believe it was, yes, there was one, I don't recall, I believe it was Blue Armor.
And that's a private security company?
Yes.
And they provided security?
They were there for a short amount of time.
Do you have personal knowledge as to why it was the constable's office was not providing security?
Not personal knowledge.
So, Your Honor, subject to having those items admitted into evidence, I pass the witness.
Mr. Ross?
Ms. Garza, I guess the warrants in question that we're talking about, this was February of 2017 to April of 2017. that right?
Based on the summary, yes.
It's February 21st to April 12th, so we're talking about something that was going on for about a month and a half.
Based on the summary, yes.
Right. And the summary is based on, I guess, what you provided as
Right.
custodian, correct? And that was a month and a half at the beginning of Constable Vela's term.
Yes.
And Your Honor, at this time, the defense would like the court to take judicial notice of the statute. It is Article 103.0025 in the Code of Criminal Procedure.
103.
0.0025.
Okay.
And we would like to read that statute into the record.
Go ahead.
Alternate payment procedure for certain past due fines and costs. This article applies to a defendant's past due payment on a judgment for a fine and related court costs if a habeas pro fine has been issued in the case. Notwithstanding any other provision of law, the court may adopt an alternative procedure for collecting a past due payment described by subsection A. Under the procedure, a peace officer who executes a habeas pro fine or who is authorized to arrest a defendant on other grounds and knows that the defendant owes a past due payment described by subsection A, 1, shall inform the defendant of A, the possibility of making an immediate payment of the fine and related court costs by use of a credit or debit card, and B, the defendant's available alternatives to making an immediate payment, and 2, may accept on behalf of the court the defendant's immediate payment of the fine and related court costs by use of a credit or debit card, after which the peace officer may release the defendant as appropriate based on the officer's authority for the arrest. C, a peace officer accepting a payment under subsection B2 may also accept payment for fees for the issuance and execution of the habeas pro fine. And Your Honor, that concludes the statute that we'd like to read and have the court take judicial notice of.
Any questions for the witness?
Yes, Your Honor. So, Ms. Garza, I know that you made the distinction between a habeas pro fine and a warrant. So, I'd like you to tell me a little bit more. You said that a warrant issued for an arrest is, I guess, when would that happen when it's not a habeas pro fine?
When the defendant fails to show up for their arraignment docket.
Okay. So the defendant fails to show up, a warrant is issued, and then they're arrested on that warrant. And the difference, I guess, what you're saying is a habeas pro fine would be a defendant has shown up in court, has been assessed a fine or a penalty or a condition, such as get driver's education or whatever. And that person that doesn't do those things, and then the judge issues a warrant based upon it.
Correct.
Okay.
And what are these exhibits? Which category of warrants were they?
Both, apparently. So, and these include both habeas and warrants, is that
Correct.
right? So, do you know how much of which?
No, not off the top of my head, no.
Okay. So, this was a practice.
Well, hang on, are they coded differently?
This summary identifies which is which. And yes, on the documents, you can actually read which is which.
Okay. So take a look at the summary and tell me which is which.
I mean, this is subject to the fact I haven't been able to say that the summary is accurate, but I count on their summary out of the 93, 38 are warrants and the rest is habeas. This practice, I guess, was going on for about a month and a half, and then stopped, and that's why that's all we have. That's all you.
Correct.
Yeah. At the beginning of the constable's term.
Yes.
Okay. And you discussed security at, I guess, security at the door. And you talked about your knowledge of it. Where did you get this knowledge of what was going on with the security?
By being there?
Okay. I mean, privy to the emails the constable sent saying, I'm the person that's responsible for doing security at the JP2 center.
No.
Okay, so you didn't know that, but you agree because you said that the constable's office is who is responsible for the security.
To my understanding, when I came into the JP office, I was told that security would be provided by the constable's office.
Right, but you didn't understand if it was a situation, for instance, if Judge Mesa told Hunter Salazar, I don't want Bexar County Sheriff's in here anymore, I want my own security service in here. You don't know if that was occurring.
I know at one point Judge Vasquez was trying to get private security, yes.
Right, and telling the constable he didn't want her to provide security.
What was discussed between them, no, I don't know what was discussed.
Okay. And so your understanding of this doesn't, I guess, is missing those pieces if those pieces exist, because you don't know about them.
Right, I wasn't in non-conversations.
And were you present when Judge Vasquez had their outburst, when he had his outburst at Lieutenant Minor and was screaming at him?
Your Honor, objection motion.
Overruled.
I vaguely remember in the situation, yes.
Okay, so you were present for that outburst?
Yes.
Okay. And did you feel like Judge Vasquez that was that he was acting in a professional manner towards Lieutenant Minor or members of the precinct?
Your Honor, objection. This has nothing to do with security. This is outside 3707.
I don't know what it has to do with.
Well, I can tell you if the objection is to relevance, what I'm establishing is that the way, kind of the theme throughout, the way they made it seem is she just, I'm not doing security, whatever. What was happening is Judge Vasquez was telling her, I don't want you to provide security, and then they went to the commissioner's court to argue about
Objection
it.
is overruled. She can testify what she knows or what she remembers.
You feel like that he was acting in a professional way when he had that outburst?
I would say he was acting in the best interest of his staff, yes.
Okay. And so, would you say that Judge Vasquez did not like Constable Vela, to your knowledge?
I couldn't tell you either way.
You don't know if he had a personal problem with her?
I wouldn't know.
Okay. Well, you know, the fines that we're talking about here, they were directed to be paid at the Justice of the Peace window, weren't they? And you can see that on your things, that they were being paid at Justice of the Peace.
Not all of them were paid at the window, no.
Okay, so the other ones that were paid, I just want to clear up that money went to, they were paid through a portal that's provided by, however they're paid. They're paid through a portal that's provided by the Justice of the Peace, and the money goes to the Justice of the Peace.
Correct.
Okay. It wasn't like they were taking money from these people and pocketing them. They were getting the fines paid, and that was registered that they were paying their fines, and that their fines were covered, whatever they had. Right?
Yes.
And were you present when Judge Vasquez ordered the constable's office to take the mags off, or the magnetron, or the metal detectors?
Was I present with what?
When Judge Vasquez told the constable's office to remove the metal detectors?
No.
Okay. Colonel, we don't have any further questions.
No, I have a couple more questions.
I'm sorry.
Were you present in any of the meetings between Constable Vela and Judge Vasquez regarding these collection of fines and fees?
I don't recall being present, no.
Okay. No further, well, hold on, just one second. Just subject to admitting those into evidence, I don't have any further questions.
Your Honor, I don't have anything further, but we would like the subject to recall in our case whenever that comes around.
Okay, just make sure you stay in touch with the DA's office. So in case they need you back here to testify, whether it's this week or in a future date, we're able. Okay. Thank you, Mike. Thanks, Let's take a morning break so that you can at least inspect those exhibits. 15 minutes.
calls Judge Roberto Vasquez. And Your Honor, am I going to be able to utilize any of these records?
He said he's not done reviewing that.
Yeah, okay. So what I'll say is this, we have time. I would just ask for the court, as far, what I'm concerned about is the summary says, oh, this is a KPS, this is a warrant, this is a KPS, this is a warrant. I want to make sure that this is a KPS, this is the warrant. I want to make sure the summary accurately reflects what is being
You
prompted.
only have to check 38 because that's what was a KPS.
Or a warrant,
Or a
yeah.
warrant.
Yeah, I agree with that, and so that's really what I'm trying to do. That's fine if we do that, if I'm able to correct the summary later with the court after I've checked all that stuff and say, Judge, actually.
I'm not saying I'm admitting it right now. I'm saying please check just the 38 that were in
Yes.
actual warrant, not a KPS profile.
Yes, Your Honor, and I don't have any other issue with Judge Vasquez or whoever testifying on the document. Which is what our question.
It just, I'm not sure if it'll come up, but I just wanted to be sure I could go into that.
Okay.
Good morning. Yes, sir.
Vasquez, you were previously sworn, you remain under that same oath. Okay?
Yes, Judge.
Thank you. You may proceed.
Thank you, Your Honor. Could you please state your name for the record?
Roberto Vasquez.
And could you please spell Vasquez?
Vazquez.
Thank you. And what is your job title?
Right now, I'm the Justice of the Peace in Precinct 2, Bexar County, Texas.
And how long have you been in that position?
I'm completing my 10th year currently.
And prior to becoming the Justice of the Peace for Precinct 2, what did you do?
I was a licensed attorney, and I was also a municipal court judge, court of record for the city of San Antonio for 7 years.
And how long have you been practicing law?
I received my license in May of 1995.
So, 10 years as the JP2 Justice of the Peace, what year when that opinion came into office?
January 1st, 2013.
And who was the constable for Precinct 2 at that time, if you recall?
I believe it was Val Flores.
And was there any subsequent constable prior to Constable Vela, between Val Flores and Constable Vela? Only if you remember.
No, I believe Vela was the second constable who came in during my tenure.
I see. So today I would like to go over the situation with the 93 KPS and alias warrants. We already had Renee Garcia testify, and those documents right there you see in those binders, those are the records that we'll be referring to. So when you first came into office, not when you first came into office, when Constable Vela first came into office in January of 2017, did you have an occasion to meet with her?
Yes, I had several occasions when she first became constable to speak with her, basically as two elected officials who they serve the JP warrants. We worked closely on a lot of things, so we just wanted to make sure that we were kind of welcoming and trying to get to know the new individual that came in to be constable.
And one of the subject matters that you covered during that time, did it include collecting fines and fees on the KPS pro-fine warrants and alias warrants?
Yes.
Do you recall about when that was that you had that conversation?
The conversations probably started in late January and continued right through March, middle of March, early April of 2017.
Your Honor, what is State's Exhibit 130 the next number?
Yes, ma'am, 130.
I'm going to hand you what's marked as State's Exhibit 130. Do you recognize the cover sheet there?
Yes, I do.
And what is that essentially?
It's my affidavit as a custodian of records for records from the Justice of the Peace Court.
And how many pages are included behind that cover sheet? Or together?
43.
43, okay. I'm going to have you just hold on to that to refresh your memory. I'm not going to admit those into evidence. Included in those would be what types of documents?
Well, some of the documents in here relate to media coverage, events, emails between the offices appear to be emails between myself and the district attorney's office and Constable Bella Barrientes.
Just a variety of things that you would maintain.
Absolutely.
Okay. So, and there are dates related to some of the subject matter we're going to cover, and I just have that there in case you need to refresh your memory.
So prior to Constable Bella coming into office, were you monitoring how fines and fees were being collected by agencies that have warrants arising out of your court?
Monitoring, not necessarily. I assess fines. If you're speaking specifically to warrants, those warrants go out and are executed by law enforcement officials. And if there's any collection of any fines, fees, court costs, things of that nature, they go through the court, which would go through the court's clerks.
So let's begin with a normal procedure for adjudicated offenses. So if you have adjudicated offenses arising out of your court, then what would be the process for the individual that is being adjudicated as far as satisfying any judgment you have issued?
Well, there's a variety of things that can take place at that point. Generally, and we can get more specific as you want, generally the court is going to sentence somebody by assessing fines, because we handle Class C misdemeanors. So the court is going to assess fines and court costs and assess any other elements of probation that need to be satisfied. And so individuals can either pay their fines and their fees when they plead guilty, and if they're not placed on any type of deferred disposition, once they satisfy that by either paying out their fines or doing community service, their case is closed. If they're placed on some type of a probation and there are elements of probation, conditions of probation that need to be met, then the court monitors those, and as necessary, even for the fine cases, we will have show cause hearings to bring folks back in to make sure that they have done what they were sentenced to do by the court.
And if the individual fails to follow the instructions of the court for satisfying those judgments, can a warrant issue?
Yes, on the adjudicated cases, that would be a capias pro fine that goes out for the individual, basically a warrant for these individuals to satisfy those judgments. And those can be executed by any law enforcement agency.
And then when it comes to unadjudicated offenses, how does the process begin?
Well, unadjudicated offenses, usually that's going to be individuals that don't ever show up to their initial court hearing, or maybe they have shown up to an initial court hearing and then they don't come back and present themselves to a court before they have entered a plea in their particular case. So these individuals are unadjudicated, and we also, the court will also place warrants, issue warrants for those individuals to show up to court.
Would those be referred to as an alias warrant?
An alias warrant, yes, ma'am.
And what are the procedures in place for, at the time, for individuals to satisfy payment of fine and fees? Would they be able to, is there a window or a clerk or a specific process in place for them to satisfy those payments?
At Justice Court 2, we have a bank of windows. If you walk into the building at Justice Court 2, that building only houses the Justice Court and the Constable's office. On one side of that building is the court's system, and all of our clerks have a bank of windows. We have a lobby that has a bank of windows, and if people want to come and just outright pay or provide information as to how they've satisfied their cases, they can do that at the proper windows with the clerks.
So if they've been adjudicated and they enter the facility, they can go straight to the window and satisfy those payments?
Oh, absolutely. They can make payments. If they can't afford to make payments, they're brought back before me, and I can assess community service hours in lieu of making those payments.
So the clerks keep track of where the individual is situated in satisfying that payment, and if it's not satisfied, they're the ones that let you know?
Oh, yes. We have a system, for monitoring each individual case. Then we have show cause hearings as necessary for those individuals that are not satisfying either their adjudicated cases by payment or the elements of the probation that they have been given, the conditions of probation.
On occasion, when there are alias warrants outstanding, do individuals just appear?
Absolutely.
And would they be able to just come in and pay, or would they first have to see you?
It depends. If they've been summoned to court, everything takes place in front of the judge in the courtroom. If somebody walks into the building on an alias warrant, they've not shown up to court, but they want to come and try to satisfy that or at least get that warrant removed, they will enter the building and go to the court side and go to the lobby windows where our clerks are, present whatever it is they may have, and if they're able to satisfy what we call an ordered window fee, that's where all the judges in Bexar County have already set certain fines that they will accept on cases. If they can do that, that's fine. If they want to set up a payment plan, that's fine too. If they're just coming in and they want a court date because maybe they can't pay for anything, so they're going to have to go before a judge. If I happen to be in the building, they'll bring them right to me, and I can see them right away off docket. Many times, we may be having other dockets, and individuals don't want to wait, so we'll set them up on the next available arraignment docket, and they can come back before a judge, or myself in this case.
So, when there are active alias warrants or habeas profile warrants, generally speaking, who is it that you rely upon to carry out an arrest or a confinement of an individual for the failure to satisfy the purpose of the warrant?
The bulk of my justice court's warrants, those are usually executed by the constable from Precinct 2, the constable's office from Precinct 2, so it'll be the deputies in that office.
And they're able to access the system that you've referred to?
Yes.
And so is it something that they just regularly check into on a daily basis to see what's active?
It is my understanding that they have access to that.
And then I would imagine the remainder of the cases not executed by Constable Precinct 2 those are things that might, another agency might just come upon an individual who has an active warrant out of your court?
Correct.
So what are the options for a law enforcement agency when they come upon an individual with either an alias warrant or a habeas profile warrant? What are their options regarding the satisfying the outstanding warrant?
When a law enforcement official executes and acts upon one of my warrants, they are directed to arrest that individual and bring them before myself or the local magistrate so that they can either enter a plea or get a new court date, depending on what the court wants to do. So everybody who's got any type of warrant from Precinct 2 needs to be brought before a judge, myself, or we have here in Bexar County, we got 24-hour local magistrates down on Frio Street.
Is there a situation that could occur that they come upon an individual with an active warrant and they do not actually have them magistrated? Are they able to do that?
Not lawfully.
So we previously had the court take judicial notice of the Article 103.0025 alternative payment procedure for certain past due fines and costs. And are you familiar with this article?
Off the top of my head, I believe that that's the capious statute on how to put in place a process. The court may do that for adjudicated capious cases. I believe that's the statute.
Yeah, let me give you a copy.
Is that what you're familiar with?
Yes.
So that particular statute, what is that referring to?
These are procedures for capious warrants. That would be cases that have already been adjudicated. And the law allows a court to put procedures in place for collecting past due payments. In Justice Court 2, we do not have a procedure that is agreed upon, that is put in place by the judge and agreed upon by a local law enforcement official. There's no such thing that we have in place. So everybody that gets picked up on a capious warrant has to be brought before a judge.
So the distinction between the adjudicated and the unadjudicated being the alias warrants, those must always go to magistration?
They must all be brought before a judge, absolutely.
So there's no possibility under a statute that a payment plan can be procured under an alias warrant?
Not that I am aware of.
So then we move to the adjudicated, which is the capious pro fine warrants. So what you're saying is based on the statute, unless you, the court, has an agreement with whatever, and it would be the constable's office, or could it be any agency?
I believe it's the constable's office in this instance.
Okay, so without an agreement between you, the court, and the constable of Precinct 2, there is no way for them to bring in an individual without magistration?
Correct.
So at the time that Constable Vela was in office and she came into office, newly into office, let's go back to when you first had a conversation with her related to this issue. You believe it was sometime in January of 2017?
Correct.
And what was it that you brought to her attention about this particular issue?
I believe the first conversation that I had with her, I walked over to her office with a code of criminal procedure in my hand, and also my court manager at the time was with me. Walked over because I wanted to diplomatically explain to her some issues that we had had in the past with other constables here in Bexar County that we had straightened out over the years. And the issue was this of what you can and can't do, what a law enforcement official can and can't do on these alias and capious profile warrants. Unfortunately, that meeting did not go very well, because when I tried to explain to her what was in the Code of Criminal Procedure, I didn't want her to think that I was telling her, hey, this is the law, this is how I understand it, and here it is. I wanted to actually show her in the Code of Criminal Procedure that there was something in the state law, in our books, that has been passed by the legislature, and show her where it was. And I was met with a pushing of the Code of Criminal Procedure statutes away from me, and her letting me know that she knew the Code of Criminal Procedure better than any lawyer or judge, so I didn't have to worry about it, which caught me off guard because I had never kind of heard that type of language from a law enforcement official or another judge. As a matter of fact, I don't know of anybody that I have ever met in my legal career who has...
What caught him off guard, and how many people he's never heard before?
You can continue.
In my career, I don't think I've ever heard from anybody in the legal community that says that they know everything in the Code of Criminal Procedure.
Objective relevance. I mean, this is...
I'll give you a writing objection, but it's overruled.
Thank you, Your Honor.
So, did the meeting end at that point, or did you...
I brought it to a close because at that point I was well aware that this was going to be a very bumpy ride, and I needed to make sure that the court protected itself in everything that it did.
So upon leaving that meeting, did you know whether or not she was going to comply with the Code of Criminal Procedure, in that she could only take either of these types of warrants to magistration, or did you think that she was going to continue to collect fines and fees?
My opinion was that she did not have a grasp on what she was supposed to do and not do.
This opinion is not an expert witness. And Your Honor, if you please instruct the witness to pause. He is a lawyer. He understands when I stand up to object to stop talking.
Judge, let him do his objection, and then you can keep answering.
Absolutely. And counsel, if you'll speak up a little bit, I'll immediately stop.
Understand. If I stand up, that also means I'm about to speak.
I'm not watching, so if you like just object loud, I'll stop.
You don't tell me when to object.
Okay, thank you, sir.
Can we keep going in my courtroom, please?
Yes,
the way that I say so. Thank you.
Yes, Your Honor.
Go ahead.
So, we've had previous testimony that in those binders there are 93 warrants, to include both alias warrants and capious profile warrants, that began in February 21st of 2017 and went all the way through to April 12th of 2017. So regarding those particular documents that were collected, why was it necessary to collect those documents?
Those documents are kept in the ordinary course of our business at Justice Court. What those documents, they raised red flags because we found a pattern that with these particular defendants, they were not being brought before any court after a warrant was executed.
Despite which kind of warrant?
Both alias and capious profile warrants.
And after you just established that there was no agreement under Article 103.0025, both types of warrants would have required magistration.
Yes.
And being taken before a judge, whether it be you or any other magistrate.
Yes, ma'am.
So, over the course of this time where you're monitoring these documents as red flags, were you trying to get assistance with resolving the issue?
Yes,
And who did you reach out for assistance?
to the district attorney's office.
And why would you reach out to the district attorney's office? How are they related to this issue?
We had, I had an ongoing conversation with the constable and raising this issue with her, but it was not met with any kind of resolution. Because there were so many of them, the court has the right to hold all of these law enforcement officials in contempt of court for not executing these warrants properly and bringing them before the court. Because there was so many of these, it didn't look like it was just a one-off or two-off or three-off deal. When you have so many of these in a short amount of time, it looks like, in my opinion, there was some type of an order.
Speculation is irrelevant.
Overruled?
There was some type of an order coming from the head of the agency as to how these things should happen. So
Your Honor, I'm sorry, objection. There's no way that he, in his opinion, could divine that there was some order coming from the head of the agency.
So when you talked about being able to find a law enforcement agency in contempt of court, I'm going to hand you Section 86.024 from the local government code, failure to execute process. Is that what you were referring to?
yes,
Your Honor, will you take judicial notice of local government code section 86.024, failure to execute process? I actually have a copy.
I will take judicial notice of that provision of the government code.
I would like a copy.
We'll have to print that out. When you're ever in need of counsel on civil issues, is the district attorney's office, civil division, who you turn to generally, or the district attorney?
both. And in this particular matter, I did send an email on March 10th to the constable trying to be diplomatic and explaining the different procedures in the Code of Criminal Procedure for the capious warrants and the alias warrants. And in that email, I even bolded that it was not the intent of the court to issue contempt orders. The court was just trying to make sure that the constable was following the law. That was during the time and before that we had started communication with the DA's office to delve into this issue.
So not only did you do meeting in person, but you tried to communicate in writing as well, just to set out what the law is and that you would hope it would be followed.
The email from March 10th is self-explanatory.
And that was directly to Constable Vela?
Correct.
And was there a response to your communications with her via email? regarding that?
I did copy Nico LaHood, Woody Halstead, and my court manager Rita Burke on that email. And then there was a reply that was very nonsensical to that email.
From Constable Vela?
Correct.
So just to be clear, Nico LaHood was the district attorney at the time,
Correct.
and Woody Halstead was his first assistant?
Correct.
And did you subsequently have to have further conversations or communications with them?
We had a meeting, I believe it was on March 21st of 2017, between myself, Constable Vela, Nico LaHood, and Woody Halstead
And where was that meeting held?
in this building in the DA's office.
And what was the purpose of the meeting?
To resolve this issue of these individuals, defendants that were being brought before any judge on these warrants.
And during the course of that meeting, was the defendant directed to cease and desist this activity?
You mean the constable?
I'm sorry, yes.
The constable, yes, was directed by the DA and Woody. Mr. Halstead was given direction that this was not lawful.
And did she respond that she would comply?
I don't remember her saying that she would comply or not comply.
But we know from the documents that this activity continued until April 12th of 2017.
Correct.
You stated the meeting was on March 21st of 2017?
I believe so.
So shortly thereafter, it finally did stop?
It trickled off after that meeting, but it didn't stop immediately.
So let's talk about the consequence of an individual not being magistrated pursuant to law. If an adjudicated individual with their habeas pro fine warrant active is not brought before you, what are they missing out on?
It's the very heart of our constitutional system. There's a separation of power.
We're all always here. It's not necessary for him to explain the magistrature process.
So
It's the very heart of our constitutional system. You have a separation of powers between the executive, which the law enforcement officials fall under, and the judicial. Any branch of government doesn't get to dictate explicitly everything on any type of an issue. Here, with our justice system, the executive goes out and executes those warrants and then brings them over to the judicial so that there's the checks and balances in our system. When they're not being brought to the justice system, one branch of government is directing every aspect of the justice system.
So you're saying like a denial of due process?
Exactly.
So when an individual is adjudicated and they have a habeas pro fine and they're actually brought to you, do you necessarily order them to go to jail, or do you have other options at your disposal?
In all frankness, with Class C misdemeanors, I try to do everything to avoid sending somebody to jail. So when they come in with a habeas warrant, the case that's already been adjudicated, I want to find out the reasons why this is happening, and many times, probably 95% of the time, it's either a financial or there's some physical impairment.
And the options that you have by your discretion as the justice of the peace, you don't necessarily have to send them to jail. You can provide alternative resolutions.
I have at my disposal a wide array of alternative dispositions to take care of somebody, from right down to suspending all of the fines based on their circumstance, to having them pay, to having them do community service, these types of actions.
So if you were available and an individual was picked up on their KPS profile warrant and they were not taken to you, they perhaps could have missed out on all those potential opportunities.
They would have, absolutely.
Now, had you not been available and magistration would have occurred elsewhere, what would another magistrate be able to provide? Would it just be the booking, or could they also do other options?
Here locally, those magistrates have been given authority to exercise their discretion when somebody's brought in on these justice of the peace warrants.
Similar to yours?
Absolutely, yes.
And regarding the alias warrants, when they're brought directly before you, what do you have at your disposal at that time? Is it all the same options?
Well, the very first thing that we have to do on the alias warrant is we have to take a plea. They've got to first enter a plea of guilty, not guilty, no contest, or some other plea, but those are the three major pleas. That's the very first thing that we have to do, because remember, just because there's an alias warrant out for somebody, that doesn't mean that that individual is guilty of anything. We have to go through a trial system.
So that they get to make their plea to the court, and then you follow whatever that plea might be, then you take that direction.
Absolutely. So obviously, if somebody pleads not guilty, the next step is to get them on a trial docket. If they plead guilty or no contest, then I'm either going to take recommendations from the DA on what the sentencing should be, or at the Class C level, I don't even need the DAs there by law. I can go ahead and you can plead to me, and I can assess the punishment at that point.
And at that point as well, can you also recall the warrant and not have them booked into the jail?
As soon as somebody walks in with a warrant in any justice court here in Bexar County, the warrant is deemed to be automatically lifted. And the reason that we do that is because we want people coming to the courts to take care of these Class C misdemeanors. And if we have people being arrested at the door, then that's going to have a chilling effect on individuals coming in to take care of these Class C misdemeanors. And that's by order, and then it was codified in one of the last two sessions of the legislature, but we've been doing that here in Bexar County for a while, which I think is a tremendous policy and order.
So are you saying that when an individual with an outstanding warrant approached the door of the JP at one time, at JP2, I mean Precinct 2, so the Precinct 2 has the main doors. If they came in and they had a warrant, that they might not be brought to you?
In the past, during my tenure, individuals who came in on warrants, if what you have is a security officer at the door, which is usually a reserve constable or a reserve deputy constable or an active deputy constable. So when individuals come in, if they would have happened to tell them that they were there because they got a warrant, at times they were being whisked away and arrested. That procedure right there just flew in the face, in my opinion and the opinion of the other JPs, of common sense. Because if you're arresting people at the door and then the community knows that you can't come in with a warrant, they're not going to come in to take care of these warrants. It has that chilling effect. So the JPs in Bexar County, and I can't remember exactly when it was, but I want to say 2014 or 15, that we put a standing order in place that any warrant issued by a JP court was deemed lifted if they walked into a justice court building.
So the very last page of the records that you provided under the business records affidavit, there's a document attached. Is that what you're referring to?
Yes, August 5th of 2017. Yes.
And that came about as a result of the fact that it became an issue that individuals were not being permitted free access into the facility as far as satisfying, making himself appear before the court?
Correct. And I can't speak to how exactly the court picked up the information, but it was seeping out into the community and we were getting it through phone calls. And that's exactly what we didn't want. And actually, we were correct in our judgment because the legislature, I believe in either 2019 or 2021, actually codified that policy.
I see. Did you have communications with Constable Vela regarding that issue prior to your codification order?
Correct. Prior to the order, yes.
And did you meet the same resistance with that communication as well?
Every conversation pretty much with the constable was met with resistance when we talked about legal issues. We could not ever have a high-level legal conversation. Everything, it was very difficult to stay diplomatic.
So based on the 93 warrants that did occur between February 2017 and April of 2017, was there a consequence regarding these individuals and the disposition because of the way it was handled? Did you have to return monies or did you have to do anything in the computer system related to these individuals?
As best as we could, I gave the order to my court clerk to go back through all of those individuals and find any monies that had been collected and return those monies and summon those people to court.
And why did you do that?
Again, because I didn't know how deep this was, and we had already started the conversations with the DA's office. I thought that was the best, in the interest of justice, I thought that was the best policy. And also, I think in the back of my mind, I thought there might be some liability here for the county of Bear on these issues, and I wanted to mitigate any of that.
So you felt like you had to remedy the denial of due process?
Absolutely.
Regarding the security issues, is the constable of Precinct 2 responsible for security for the facility as well as your court?
Right now they are. Right now they are. They have been in the past. It's been a point of discussion with Commissioner's Court as to how best to secure that facility because it houses 2 courtrooms and the constable's office. But historically, the constable has been the quote-unquote lobby security for everybody who comes into the building.
So back...
they got to go through a metal detector and things like that.
So and the metal detector's at the front entrance, right when people enter in?
At that location, there's only one way in, one way out for the public.
Okay. And so typically a security will be provided right there at the entrance?
Correct.
And the security would have been, as you mentioned earlier, usually a reserve deputy constable?
It's my understanding, and this is from talking to constables, it's usually a reserve or it can be an active deputy constable.
So back in 2017, did security become an issue when Constable Vela came into office, or at least during the tenure?
We had one major incident that actually put myself in danger and the public in danger, which was very egregious. The constable appeared to be upset after the 2018 budgetary process, which would have taken place in September. They would have adopted the budget in September of 2017 to roll forward beginning October 1st of 2017. That would be called fiscal year 2018. Apparently, during that time, the Commissioner's Court cut some positions from her office, and it escalated over the subsequent months of September, October, November into the new year, where she told the court that she was no longer going to be providing security for the building. She would have security for the court in the form of a bailiff, which brings up a whole nother can of worms. But she went so far as to remove the metal detector from the front door and just leave the front door wide open during a day. That metal detector, by the way, was the court's property. She just removed the manning of the door and then absconded with the metal detector to her office, which was egregious. So we were left, if you can imagine, in a courtroom with litigants, and there's no security at the front door.
So what was your reaction to that as far as getting security?
Well, my reaction was the only one that I could. I called the sheriff to try to get some security, and I called my commissioner, Paul Elizondo, and I may have called David Smith. I may have also called, I believe, David Smith and County Judge Nelson Wolf to let them know what was happening. Once again, we have that separation of powers. The county has to provide us with all of the implements that we need to run the justice system. So it's their building, and it's my courtroom, it's their building. They had to be notified immediately to secure that front door, right?
And how did they do that?
The sheriff came out with some of his deputies, and there was back and forth over several hours, and then the metal detector was put back in place. But it was a harrowing time there, over about 24, 36 hours, because there had been discussion of bringing blue armor out there because security had been so lax, issues with security. These are all things that the Justice Court doesn't even wish to involve itself in, right? We just want to come to court and adjudicate cases and take care of the justice system, not have to worry about whether we're secure or not.
And Blue Armor and being a third-party security company?
Correct, that apparently does a lot of business with the county, or has done a lot of business with the county.
So after this 24 to 36 hours issue of the security, was security then back in place by Precinct 2?
If my memory serves me correctly, eventually Precinct 2 Constable's office was back in security of that front door.
I'm going to show you a copy of an Attorney General Opinion GA-0940. Is this one of the authorities referenced in your email, in your communications with Constable Vela?
I can't remember if this particular opinion was mentioned in the email, but I'm not sure what is quite contained in this opinion without reading it. But I do know that the codes are, the law actually carries more weight than this opinion, and the law is going to govern exactly what we do.
Your Honor,
He doesn't recognize it. It's something he ever said, that's not relevant. Yeah. It was testimony about it.
Your Honor, I'd like you to take judicial notice of opinion GA-0940. This is an Attorney General opinion under Greg Abbott, May 29, 2012. It's related to the authority of a constable with regard to payment of outstanding warrants issued by a justice court.
And I'll take judicial notice, but the judge just said that the law governs, not an opinion.
Well, but it is still authority.
I will take judicial notice, which we have given a copy to the defense counsel.
Related to the metal detector that you mentioned, does that come out of your budget with that paid for that metal detector?
Yes, the Justice Court's budget paid for that metal detector.
Regarding the computer system that is shared with the constable's office as well as the court, especially in relation to these 93 warrants, when the precinct 2 constable's office collected the fine and fee, how was it that the warrant was no longer active after that point? Did they have to do something in the system to stop that active warrant, or how did that work?
Well, in this technology age, everything is digitized. So I have an order that is a written document, and it gets digitized. And then as they execute these warrants, the individuals that have access to that system can then do whatever they need to do on the keyboard to make sure. I'm not quite sure exactly what they did at that point to make the warrant either appear closed out or no longer active. I didn't have any exposure to that. The clerks.
But that is what occurred on the system?
Correct.
However, who has authority to recall the warrant?
There's only one person, and that's the judge.
And you did not recall those warrants at that time?
Did not recall any one of those warrants.
I'm going to pass the witness.
We're actually going to take a lunch break. So, Judge, if you want to step down, I'll tell the attorneys what's going to have you back. I do need to see the attorneys as well as the attorneys for Mark Garcia at the bench.
what time did you say to be back? 1 p.m.
Rules of the Texas Professional Conduct regarding ethics and conflicts of representation, and I'm very concerned, Mr. Sanchez, that there is the possibility that you have created a conflict in your own representation. I understand the state represented that they were under the impression there was a consent by Ms. Barrientes Vela to waive any conflict.
On the federal case.
Right, so if she has not waived or consented to the joint representation in this case, and it sounds like now this is adverse to her and prejudicial to her, and I need you guys to review those rules. During lunch, I'm going to give you a longer break for lunch so you can review them. It's my concern, and also it sounds like you have to withdraw from representing Mark Garcia is what the rules call for. I don't want to inquire further. I just need to put that out there. It is a problem, and it may very well lead to him not being able to testify if there was a joint representation and now the tables have turned. I do believe that's a problem, so he may not be allowed to testify. If he needs me to appoint him an attorney, I will, but I believe your entire office is disqualified under the rules. Check the rules. If you want to bring me case law, bring me case law.
So, Your Honor, this issue I did look into at the time, and I went to my appeals division, and they said individuals have very, very strong rights when it comes to their representation, and that I was not permitted to have anyone recused. And so I did look into the matter at the time.
And I'm reading straight out of the Texas Rules of Disciplinary Conduct. Like
They
it's
did
an
research
ethical issue.
and they pulled the case law.
They're welcome to come after lunch, but that's my position right now. Reading the law, that if she has not consented specifically to him testifying against her, and there was at one point a joint representation, she needs to consent, and her consent needs to be informed. So I'm going to give you a little bit extra longer break so that you can have some time to research this issue. I don't want to waste a lot of time on it because we can bring it back up tomorrow afternoon. I want to get these witnesses back to work. So I'll give you some time to research, but really probably we'll take this up tomorrow. Please talk to your client. Let's reconvene at 2 o'clock. I want to give you guys some time to look into that and give me, and I'm going to keep looking myself. So 2 o'clock. The judge back on, finish his cross.
Did you want to address anything related to defense counsel from Mark Garcia?
I don't want to hold up the witnesses. I mean, is it going to be quick? 'Cause-
It should be, just, they wanted to tell you their progress over the
yeah,
lunch hour.
that's fine. That's fine. Come on. Coordinator Ashley, alert her that he's here and that he would like to get a court-appointed attorney.
We can.
But if not, who is the attorney that he's going to see?
I didn't really want to, because he hasn't been changed yet.
I guess I'm trying to ask if there's no conflict there.
No.
Okay.
Completely.
It's not trade
No conflict between
Yeah.
this
No.
side and the new attorney.
That's just-
Like, don't know each other, never consulted.
We ran those traps.
Perfect. Okay, so file your motion. I'll rule on it tomorrow. Just please have your client be back here tomorrow, and I want him to keep his appointment. Please. Okay.
And Your Honor, I just said that it's our contention it doesn't change the Sixth Amendment violation. And so this does not fix what's happened, because what's happened's already happened. The contract's already signed.
I understand that.
Okay.
That's not
Is
what
that
I'm
a time-
ruling on right now.
Got it. So there'll be a time for us to argue
Actually,
that.
this part is the only part that I feel very strongly about, that they need to withdraw just to preserve,
Preserve the record, yeah.
any possible complaints. I mean, I know I can't stop anything, but they need to protect their license. So I'm 100% feel strongly that they should withdraw, and they've done. So file
Understood.
your motion, give them a chance.
Can we have defense counsel file their motion related to this issue so that we know what their legal basis is?
Yeah. I mean, not right now, but yeah.
We will work as hard as we can. I mean, we did have some little bit of research done, and I'll just tell the court in the state that Kyler v. Sullivan, which is 466 U.S. 335, which just talks about the 6-minute right to counsel, includes conflict-free counsel.
I understand.
And the prejudice is presumed in a situation like this where, because what's happened is he's already given his proffer, and he's already talked to the state, and he's already done all this stuff and signed the contract. And so the prejudice in that case.
I don't want to have that argument right now.
I understand, but
Because
that's
I
that
have
would be
a
the
lot of
basis.
questions, so I don't want to have the argument right now.
Understood.
Mr. Sanchez, can you please have your client sign off
Yes.
on the withdrawal? That way we don't have to make a record.
Right. I'll have-
But if he consents, I'll sign off on it. And if you could please report tomorrow at
What time?
Tell him to be here at 1 o'clock.
1 p.m.
Yes.
Okay.
All right. Thank you, sir.
May I have the excuse to confirm?
Yes. Thank you.
And Mark Garcia, can you excuse yourself?
Yes. I want him to keep his
So
appointment.
tomorrow at what time?
Tomorrow at 1 o'clock. Let's get the judge up here, please.
US 335. 335? 335, Kyler C.
Mr. Cross.
Thank you, Your Honor. Judge Vasquez, were you subpoenaed to be here today?
Yes, sir.
And how is that subpoena served on?
I believe, if I remember correctly, honestly, I can't remember how I got it.
Okay. Do you know when you were subpoenaed?
The exact date?
Yes.
Not exactly, no.
All right. Do you know if it was this month?
No, it wasn't this month.
It was not this month.
It was not this month.
Do you know if it was last month?
It was not last month.
And so, do you know if it was this year?
I believe it was early this year, yes, I believe.
So you're subpoenaed early this year for a date that was not this date? Not August 22nd?
Correct. Correct, yes.
Okay.
I believe the trial was supposed to start earlier and then it got pushed back several times, I believe.
Understood. But you definitely want to be here to testify against Michelle?
Do I want to be here?
Yes.
I was subpoenaed to be here, and I'll do whatever I need to do to get the truth out from Justice Court too.
Well, let's talk about that.
Sure.
How many times in your position as Justice of the Peace Precinct 2, how many times have you appointed counsel to one of the defendants in front of you?
Appointed counsel?
Right.
Probably a handful of times, because we don't have any mechanism for paying appointed counsel, and most of it's done pro bono.
All right. So.
And usually I'll ask if they want to do it and find somebody.
So.
I'm assuming you're talking about criminal cases.
Right.
Okay.
Yeah. On traffic tickets.
On traffic tickets, it's got to be less than a handful.
On failures to appear.
Failures to appear?
Right.
I would say less than a handful, yeah.
All right. But, you know, the very heart of our justice system requires counsel to be appointed to anybody facing a criminal allegation. Right?
I would agree with you.
Okay. So on these traffic tickets, do you appoint counsel to everybody who gets a traffic ticket in the court?
No, we don't really have that authority to do that at the Class C level.
It's a Class C.
Class C misdemeanors.
And Class Cs are exempt from the Sixth Amendment right to counsel.
Okay.
Right.
Okay.
I mean,
I agree with you.
You're a lawyer, you're the judge.
Mm-hmm.
So you agree, and my point being that you would agree that the very heart of our justice system, as you described it, there are some constitutional rights some people have that they don't necessarily have in your court on Class C misdemeanors.
I guess that's fair.
Right, because almost all of the defendants in your court either hire their own counsel or they represent themselves.
The vast majority are pro se, meaning they represent themselves.
Right. So, and I don't know, I'm going to ask you about, and you're okay with that? You're okay with that part of our justice system being not necessarily applied to Class C misdemeanors in your court?
I think we can have a philosophical discussion about that, and I think we could make arguments for and against. But at that Class C level, as it stands right now, yes, you don't have those protections that you would necessarily have in other courts.
Sure. And then, you know, I'll just so I can understand how y'all work, and I'll describe my personal situation. I got a speeding ticket in San Antonio, and I got a letter in the mail that said, if you want to pay the fine through the mail, you can do that right now. And I could, if I wanted to, pay the fine, send it in, and be done with it, and never have to appear in court. Do you guys in Precinct 2, do you all send out notices like that?
From time to time, yes, and there's also the county contracts for collections, and they'll send out letters on habeas and capias warrants, and those documents and letters, and maybe it was in your case too, they will have an amount that can satisfy a plea that you enter that has been agreed to by, in our case, the justice courts.
Right.
Judges.
And you could, without me ever appearing in front of any magistrate or any judge, I could pay the fine and be done with it.
When you do that, you're entering a plea if you send that by mail. I'm assuming you're saying you're sending something back by mail?
Well, I mean, I would never do it, I just know that they give us the option.
Right, okay, well,
But yes.
if that's our discussion, then yes, if a defendant wants to pay by mail, in their mind, they're paying by mail. Legally, what they're doing is they're entering a plea when that gets to the court, and there's a check in there for, say, hey, we'll accept $187, and $187 comes in, that's as good as a plea of no contest.
Right, and then they get a conviction, and they don't go in front of a judge, and they don't.
They may not necessarily get a conviction because deferred is still an option.
Okay, or they may get deferred. The other thing that you testified about was you said that you were talking about the difference between the capias and the alias. And capias is when they've already had something and they haven't followed whatever the disposition is, and then the alias is when they haven't been disposed of yet. There isn't a disposition because usually they fail to appear on their ticket, right?
Adjudicated versus unadjudicated cases. Adjudicated, you get the capias pro fine. Unadjudicated, you get the alias warrant.
Right, and what you said is that what they can do, if you have an alias warrant, they discover they have an alias warrant. They may not know it's an alias warrant, they just think, okay, I got a warrant. What they can do is they can go to the lobby windows and pay the money without seeing you.
Correct. They can enter a plea at the window and pay that same agreed upon sentence window fee, is what we call it, that all the judges have agreed to.
Right, whatever that number is.
Right.
And that would be the same thing that they're paying if they were arrested on the warrant and taken to one of those windows.
Absolutely not. It can be completely different things. When you come before me, there's a whole lot of other things that come into play.
Well, I guess what I'm saying is that if somebody walked in the door, said, hey, I got a warrant, and they were told, well, you can go to the window and pay it, and they went to the window and said, hey, I got this warrant, can I pay it? That number, the agreed upon amount, that agreed upon amount is like the amount of that ticket, right?
Well, first off, I just want to explain a little bit about the characterization there, because the very first thing that they have to do is they have to enter a plea. Nobody's going to tell them, hey, this is what you pay. Not the court or the court clerks. We trained that from day one. When I got to justice court, we don't engage in conversation, and nor do we ask immediately, how much do you want to pay here? Because that individual's not been convicted of anything.
Okay, I'm not asking that. I'm saying the number. I'm talking about the dollar amount of whatever it is, what the justices,
Sure.
judges have all agreed
The
upon.
window fee, let's call it that.
Window fee. That window fee is the same
Window fine.
fee whether they get arrested and go to the window or whether they walk in by themselves and go to the window.
Correct. Yeah, that sounds right. But
Right.
but you've got to enter a plea first before you can do that. There's a very important step that's missing there.
Okay, but if you get arrested and you go to the window, they'll have you enter a plea. If you said, I want to just enter a plea and get this paid, they'll have you do that.
When you get arrested, you're supposed to be brought before the judge.
I understand what you're saying, but
Right,
I'm
well, that's the
asking you
law.
this.
Mhm.
I'm asking you this.
Sure.
A person who walks in says, I have a warrant, and it's an alias warrant. I didn't appear. If they go to that window, they'll pay the window fee, which is the ticket cost that has been agreed upon.
Correct.
And the clerk will have them enter a plea.
Correct.
If they walk in and the constable or deputy or whoever's working there says, you're under arrest, and they go to the window, they say, well, I want to go to the window. They go to the window, they ask them to plea, and then they pay the fee, right?
No.
So your clerks who you've trained are not asking these people to plea when they go to that window?
When you get arrested, there's a warrant that has been executed. If you come in on your own, there's no warrant that's been executed.
No, I understand that. But what I'm saying is so when they pay at that window, we're assuming somebody's been arrested at the front door.
Arrested at the front door?
Right.
That shouldn't be happening right now. We've got an order in place, and it's codified in law. You can't do that.
Yeah, but okay. Go back with me to 2017.
Okay.
Okay?
Okay.
All right. So there wasn't an order in place in a law. You wanted it to be that way, but you're actually told by the DA's office that there's no law that says that they can't arrest them when they find out they have a warrant.
I don't recall that, but yes.
What I'm saying is you had
chronologically speaking, you're correct.
you had a preference because you felt like it was a chilling effect to arrest people who were coming in, who had offenses, who were coming in. It was a chilling effect to arrest them.
Yes, and that was the same ideas that the Supreme Court justices of the state of Texas had, because I picked it up at a seminar.
Yeah, I understand that.
Okay.
Regardless of where you got it.
Right.
That was your feeling about it in 2017, and you didn't like the practice of arresting people who had warrants.
Exactly, because we didn't do that at San Antonio Municipal Court when I was a municipal court judge of a court of record there. That we were able to see these things and see the practical applications.
I understand, but what I'm saying is you didn't like that practice, but there was no law against that practice. And in fact, the law stated, especially at the time, that when there's a warrant, that any peace officer is commanded to arrest the person by the judge who signed the warrant, which is you.
Correct. Every warrant commands them to bring them before a judge.
What I'm saying is you were signing warrants that were commanding peace officers to arrest the person who had a warrant, and yet you were also disagreeing when they arrested people who had the warrant.
We're talking about the front door versus going and knocking on somebody's house or arresting them when they pull them over in the street. When somebody's coming to the court to take care of an outstanding warrant, an arrest serves no purpose at the door.
I understand that that's your thought, but that is not in the warrant that you were signing. I command you to arrest this person unless they show up at the front door of precinct 2. It doesn't say that language in the warrant.
Correct.
Okay. And so all a peace officer has is your command to arrest them upon finding them and knowing that they have this warrant. Right? At the time, in 2017.
Correct.
Okay.
But you've got to have that warrant to execute it.
I understand, but you know, you're not making claims that people were arrested without a warrant. They haven't made that claim, that these warrants were not good warrants. All these warrants
But
were good
you would
warrants.
want your law enforcement to actually know that there was a warrant and not somebody just voice, hey, I think I got a warrant, and then you put them in cuffs and take them. That's not what you want at the front door of a justice court or any municipal court. I understand that things are different in a building like this, but a Class C fine-only misdemeanors, that's really not a way to treat the population.
I understand. And you know, keeping in mind that what I'm talking about is, it's your document commanding somebody to arrest the person. And what you're saying is that although I have commanded you to arrest the person, I do not want you to arrest the person. And you feel like those are completely, I guess, in harmony with each other.
At any time, I can rescind that warrant. Anytime. With a verbal order, I can rescind it.
I understand.
Right. And that's all we're talking about, because I did have these conversations with the constable about the front door only of the justice court system, not out in the field.
Right, but here's what
That's two totally different things.
Yeah, but here's my issue, is that you have the power, as you said,
Right.
to sign the warrant and to rescind the warrant. But what you wanted was you wanted to sign the warrant, command the officers to arrest, but also have the power over whether or not they arrest.
No, that's not a fair characterization. That's what led to the order being put in place, because these are fast-moving things, and what you're trying to do is put some policy in place that's good for the population. And one of those policies was, let's not arrest anybody at the front door. If you can't see eye to eye with the law enforcement agencies that are executing these warrants, or they need better direction, that's what led to that order being put in writing by the four JPs.
Look, I get that. And I'm not even arguing with you on whether or not it's a good policy to arrest somebody at the door. What I'm saying is that ultimately, because you said that I mischaracterized it, if the warrant is valid and it's commanding them to arrest the person, you're also saying your preference is don't arrest them if they're in a certain location at the front of the precinct. But it doesn't say that on the warrant. And in fact, any peace officer who has the warrant is commanded to arrest them upon knowing that they have the warrant. And it's signed by you, saying to do that. Am I correct in that?
I would agree with you.
Okay. And so what you're doing is you're saying, I want you, the officer, to practice your discretion over what I am commanding you to do. I want you, the officer, to think, what would Judge Vasquez want me to do? Not what he's telling me to do. What he's telling me to do is arrest this person. But what would he want me to do? And use their own discretion over your command in the warrant. Is what you're saying that's what should have been happening, and you were upset that it wasn't happening.
No, that's not at all what I was saying.
But they would have to do that. They would have to practice their own discretion and go against what you have commanded them to do in the warrant, which is arrest them on site. When they see them and when they find them, wherever you find them, you are commanded to arrest them.
Well, this is why I say mischaracterization. I'm not wanting to get into like a hostile discussion. When I say mischaracterization, basically you're asking me a lot of things and the question is very compound on these issues. So if you're talking about just the front door versus the field, it's very simple. I go to the constable, I say, this is going on at the front door. We don't need to do that here. We can act as if, through my verbal orders, this warrant has no effect when somebody's coming in of their own volition to take care of a warrant. I don't get into discussions about what happens outside that door, in the parking lot, in the field, whatever. I don't get into those law enforcement. That's their purview. That's their branch of government. That's not the court's business, right?
I understand.
Except how they execute those warrants is the court's business.
Well, and so it gets back to this idea that it's their purview, except when it's not, because you defined it in a way that look, just take this as a thing that I've like automatically rescinded, whatever. But that's not on the document that they have. And knowing what we all know about what goes on with Michelle Barrientes Vela, if she had not arrested people, we would be in court talking about how she wasn't arresting people who she was commanded to arrest under a warrant. Because that's how all of this has gone. And it would be on the news, it would be on everywhere that she wasn't arresting people, and oh my gosh, Michelle Barrientes Vela is not arresting people that Judge Vasquez is commanding her to arrest.
Well, that's your question.
Yeah.
I really would like to move along.
There's not a
with this
question.
topic.
So, ultimately, do you see those two things that you're asking to be in harmony, or do you see those two as two separate ideas that you're trying to communicate at the same time?
I see that they can be reconciled, and that's what we tried to do before we had to put in effect a written order that should have just been commonsensical.
Regardless, somebody who has an alias warrant can walk in there and walk to that window and never see you at all and pay their ticket and be done.
Correct.
And on a habeas warrant, even though you said you don't like the practice, we talked about the law, and in the law, on the habeas warrant, we have the officers can take the payment right there.
No, absolutely not. There's not a process in place. That's the problem.
I understand that you don't have a process, but let's imagine JP3 has a process that you can do that. The law says that that's completely fine.
The law says what is completely fine?
Taking it right there, saying you're under arrest, you want to pay the fine, you can pay it right here.
There's a lot more to it than that, counsel.
Assume that they have the procedure in place.
We're going to assume that a court has a procedure in place.
Yes.
If a court has a procedure in place, you follow that court's procedure. Justice Court 2 does not have a procedure.
I understand.
There's nothing to follow. You follow the warrant.
I understand that, but they called you as a lawyer and a judge to opine about the law. And so I'm also asking you some of these questions.
You also understand that JPs don't have to be lawyers.
I do understand that. But I was listening closely.
I do have a law license, you're correct.
I was listening closely at the beginning of your direct examination to see if you did or not. And it turns out you did. So I feel comfortable asking you these questions about the law.
Absolutely.
Okay.
And I feel comfortable answering them as long as we can have a civil dialogue about the law. I'm cool with that.
Well, but here's the issue. I mean, and let's go back to the very heart of our justice system. And let's go back to the due process rights afforded. This practice of collecting fines from a person with a habeas warrant, that practice is completely acceptable if the court has a I guess a plan in place or whatever.
It is allowed by law.
Right. And somebody with an alias warrant can walk in and just pay it at the window and leave and never see you or never go in front of you and never be matched.
As long as they enter a plea.
Oh, okay.
Because we're leaving out these very important pieces of the justice system,
sure,
and we can't.
Guys.
Sure, but you train the clerks. So your clerks, not judges, but your clerks are asking how they plead. They plead in front of the clerk. Right?
Repeat that, I'm sorry. I didn't hear the full thing.
When they go to the window, alias warrant, walk in, go to the window, to the left or whatever, and stand in the line, sit down in front of the clerk. That clerk says, how do you plead? Guilty, not guilty, no contest. And they say, no contest. And then pay the fine, and then they walk out. And they're convicted, maybe?
Maybe.
Okay. They never saw you, right, in that scenario.
Correct.
They didn't have you explain the part of our justice system and the laws that and the rights that they have. Are you having the clerks explain their rights to them?
No.
Okay.
They're not trained lawyers, and they can't give legal advice.
I agree.
And we have to also remember that if somebody's coming in with a warrant, they're coming in off docket. They've already been given probably at least 2 summons to come to court, where I don't have to explain a whole lot of things, just like every other judge in the state at every level. But I do that because it's a Class C court, and I think it's very important that the more information that we get out to these people, because I see thousands, we get thousands of cases in here. This year we're on track for about 22,000, I believe. And if we can get it right at the justice court system, I think we're all better off as a society. And so I take great pains to explain to defendants these things, especially in criminal arraignment dockets.
I understand. This isn't a campaign commercial. I'm trying to.
I'm not on the ballot.
Well, what I'm saying is, I'm trying to ask you a specific question about whether or not, when somebody walks in and now they're sitting in front of a clerk, right? And the clerk says, "How do you plead?" And they plead and they pay and they leave. And that happens at your precinct all the time.
Yeah, it happens regularly, yes.
On an alias warrant.
On an alias warrant, an individual who has not been to their court date, never came to their court date, correct?
And you feel like that satisfies the heart of our justice system's due process requirement.
It's the law. I follow the law.
I understand, but you opined on the things around the law and why the law and the heart of the justice system. So I want to talk about.
Sure, at the Class C level, I agree with it. There are many other states where it's just you don't even get that. I think we do a good job here in the state of Texas. You still have a right to a jury trial at the Class C level if you want to invoke that. And we just had a jury trial yesterday. So, it happens.
Right. And as a baby prosecutor, I was assigned to JP courts and did jury trials in them all the time. And I guess my question is that for you, and I think you may have answered it, but for you, going to a clerk saying, how do you plead? And they say guilty, and signing something or paying the fine that's been done and leaving, that it satisfies due process as you're talking about it, as you consider due process.
I can reconcile that at the Class C misdemeanor level, yes, sir.
And that's my point, is because Class Cs are different and have different rules about due process than Class Bs, Class As, and felonies in the state of Texas.
Yes.
Right.
If that's a question, yes. I think we agree on most. There's just some real important technicalities that we got to get to.
Well, I understand, and I know that a lot of these technicalities were trying to be worked out between you and the constable at the time, which is what you testified to. right? And in fact went to the DA's office and everybody tried to figure out like, what's the law on this? Tell her the law on this, I guess is what you were trying to do.
Is that a question?
Well, I'm getting to it. Like these things, these technicalities were to the point where you're seeking outside counsel in order to try to figure out what the law is about, right?
Wrong.
Okay. Did you go to the DA's office?
Yes, the technicalities I'm speaking to are the technicalities that you and I can have as a seasoned lawyer judge, right? When a third party comes in that's not educated in these things, it's really not a technicality when you're going to serve these warrants and removing somebody's freedom and not bringing them before a judge. We didn't have any conversations in the DA's office about what is the state of the law. The law is the law. It's there. We both understood it. I was initially just trying to get the constable on board so that we wouldn't have any problems.
Well, you know, on your...
And I can't do that as another elected official to another elected official. I don't want to step on their toes. I just want to give them diplomatically the information they need to carry out their job. When that didn't happen, that's why the calls were made to the DA's office, because there's 93 individuals being affected over here.
I understand.
Sure.
But what I'm saying is that you talked to the DA's office. You did. In specific, you had a conversation about your idea that the warrant is deemed to be automatically lifted, and the DA's office told you that warrants aren't automatically lifted. You have to lift them. You can't. They can't just be automatic. You know, even if they disappear out of the clerk system, they're still going to be there until you rescind a recall or whatever else. You remember having those kind of conversations about kind of the fine minutia of what's happening with warrants and how they get taken care of and all those things.
Yeah, right. And there was, I believe there's one area where we disagreed completely, my understanding and the DA's understanding, and I believe in one of the emails, I'm not sure if it's an exhibit or been entered into evidence, and you probably have it yourself, that was subpoenaed. The first assistant actually is stating what she's doing is improper.
Yeah, well, no, so here's, I guess, the point. And let's put it in a timeline. So we're talking about, from what we saw, we're talking about the end of February to the beginning of April of 2017 is what's going on. And I know you disagree with the habeas warrants being treated this way, although you would agree that the law allows for it, right? Assuming that there's a...
Are you talking about my KPS warrants, or are you talking about just general? See, I can't answer those questions that are compound about things going on in other courts in the state of Texas. I can tell you what's happening in JP Precinct 2.
I get it. I get it. But what we're talking about, I'm going to back you out of where you're at and talk to you about as a lawyer, right? So I'm a lawyer and I can practice right here, and I can go to East Texas and I can practice Texas law over there too. But I know Texas law is the same over here and over there, right? And we're talking about the law and the statute that you were talking about. And that statute specifically says that if somebody has a capias, then and there's a judicial plan in place or whatever, I understand that, then it's totally fine to ask them for the money when they get arrested, right?
I would agree with you that, yes, if there is a procedure in place, correct. That's what the law states.
Right. And the procedure, all the procedure has to be is you saying, hey, I want you to follow that statute, and my procedure is going to be what the statute allows you to do. And I want you to do that. That it could be as simple as that.
I don't know. That's, I've never even considered seriously that statute because I think it's fraught with problems. So my thought process hasn't even crossed my mind.
All right. But the legislature obviously thinks that it's not fraught with problems because they passed it and they thought that it's a good law. And
I served as chief of staff in the legislature, so if you want to get into those conversations, I can definitely tell you about what goes on there too.
Sure. But were you chief of staff for that statute?
For that statute, no. I was chief of staff to a state representative.
So we can agree that unless the legislature repeals a law is on the books, that the legislature believes that that's a law that should be on the books.
Sure, absolutely. Okay. They pass unconstitutional laws all the time. That is not an unconstitutional statute.
Okay. So, because it doesn't violate due process, right?
Correct.
Okay.
I don't see anything that brings into constitutional question with that statute.
I understand. So, and 2/3 of these warrants that we're talking about, roughly, are off of capious warrants, which I understand you didn't have the thing in place, which your complaint is. But had there been something in place, then the law completely allows it.
When you say the thing, are you talking about a procedure for the
Right.
capious warrants?
Right.
Okay.
You say, hey, I want you to follow the statute.
First off, I don't know what the breakdown is between alias and capious warrants currently in my court. It could be, as you say, I haven't run those stats.
Well, I'm specifically just talking about these, I guess, these 90, and I think 30-something were alias, and the rest, the 60-something were capious.
Capious, okay.
Okay. So, ultimately, we're talking about a period of about a month and a couple of weeks, 5 years ago, that this was going on, that you had the issue. And, went to the DA's office, and the DA told Michelle, like, hey, don't collect on that. And you said it petered out and then it was done. And then y'all didn't have that wasn't happening anytime after that. Is that correct?
That would be a fair statement.
Okay. So the DA also told you that it's not a violation of the law, it's just a contempt issue, whether or not you can hold it in contempt. You remember that conversation?
I believe it was in the same email that said that the actions were improper, so it couldn't be reconciled, the two statements.
Well,
Right.
the idea being that
We also had a meeting on it, and at that meeting, I remember First Assistant Halstead telling me, I don't believe that she's understood 50% of what we just said in that meeting.
well, and that, I think that I understand how much you want to get out, whatever bad statement you can make about it.
I'm not making bad statements. I'm just telling you the truth.
I know how you feel about it, but
The truth is the truth.
well, let's talk about how you feel about it. You don't like her, you never have.
I don't have a feeling one way or the other about her.
Well, your dislike for her has caused you to behave in an unprofessional manner yourself. You agree with that?
No, absolutely not.
Okay, you never yelled at any of her deputies?
Yelled at her deputies,
Raised your voice?
raised my voice. I've talked to deputies in a stern fashion before. If there's something that
You never said it's not your building? This isn't your building?
this isn't your building, I
Right.
don't remember ever saying that.
Okay.
It's not, where we are housed is a county building.
Right.
It's not my building, it's not anybody else's except the county of Bear.
You remember calling sheriff's deputies to come in and do security while the constable's security was actually working in the front of the building?
I don't recall if that, I know that we had conversations between myself, David Smith, Commissioner Paul Elizondo, I believe it was Judge Nelson Wolf,
Yeah.
about how the door should be secured. Absolutely.
That's not what I'm asking. You don't remember calling sheriff's deputies to come and work security?
And the sheriff was involved in those conversations, and I may have asked if they could come and provide security while there was nobody there.
No, while somebody was there from the constable's office, while Lieutenant Minor was sitting there from the constable's office.
I can't get into the minute by minute what was happening those days. All I can tell you is the metal detector disappeared. Okay? That's one of the things I can tell you, and I can tell you what led up to that was the constable being upset with budget cuts, which had nothing to do with the Justice Court,
No.
but they took the Justice Court's equipment away.
What?
That was the prime source of security for that building.
But what wasn't actually what led up to that is that you asked the Commissioner's Court if you could have money to pay for your own security for the building.
What we had discussed was bringing in a third party like Blue Armor does here at this building, having a third party come in, which also allows more resources that the constable can have because you don't have to have people there at the door, so they could use those resources in another fashion.
I understand, but she made it clear to you that she felt that the security of the building as well as your courtrooms was her responsibility as constable of precinct 2. And she made that clear to you, and she made that clear to the auditor at Bear County at the time.
I know that she told me that she was the security of the building and then removed the metal detector.
Well, let's go back to that though. Is that your testimony here today is that you don't have any ill will or ill feeling toward her at all?
No, I don't.
Yeah.
Okay.
And I guess what is colloquially described as like a pissing contest, you weren't ever in one of those with her.
A pissing contest takes two people to want to be somehow upset with each other over some type of perceived wrongdoing. I've been there since 2013. I was a municipal court judge before that. I was chief of staff for the legislature before that. I deal with people in a very professional manner. That's all I do. And especially, I understand the relationships between two elected officials and how those two elected officials should engage with each other. And that's all I've ever tried to do. I mean, whatever she did to herself to remove herself from that office, that's her business, right? It wasn't the Rangers that came and raided my office.
So I mean, this is kind of my point, you know, and the reason I'm not objecting to it is because I think you're showing your slip a little.
That's
when
fine.
you keep inserting these things.
I want you to know the truth.
I understand.
The truth. It's just the truth.
I understand that that's what you're saying. So you don't remember Sheriff Salazar saying, "Well, I'll come do the security. If she doesn't do it, I'll come and do it." And talk.
I believe he did tell me that on a phone call and in an email. And I didn't call the San Antonio Police Department. I probably could have called them too. I didn't. I just figured we'd keep it in-house with the County of Barry.
I understand, but the way that you're portraying it is you know, innocent Judge Vasquez is just trying to get things done here, and she's coming in and taking your security away and making it, I think you described it, having a harrowing time. And that's how you're presenting it. But, in fact, there was a constant argument back and forth because you didn't want her to do security and she felt that it was her right to do it. Right?
No.
You never had that discussion with her?
We had ongoing discussions when she got her budget pulled, and I don't know exactly how that affected her office, but it ultimately led to the metal detector at the front door disappearing. For what reason, I don't know.
The reason was that you told her you didn't want her doing security at the door anymore.
That's the Justice Court's metal detector.
Did you bring anything in here to show that it came out of your budget?
I believe it's in those emails or in those exhibits right there.
And it is documentation that came out of your budget? Or did you just write in an email and it came out of your budget?
No, it came from the county. They actually went out there afterwards, took inventory and tagged everything and verified that it was out of our budget. It's in there.
Well, I mean, what you're pointing to is about...
Well, the exhibits that I refreshed my memory from that the prosecutor just showed me.
I understand. I think there was an article in there too about, I guess, how bad Trump was. That was part of your... that was part of your appalling presidency. That was part of your custodian of records duties, is keep an article like
There's a blurb. That's it looks like that might be an opinion article, and the first opinion was on the former president, and then the second blurb there is about Justice Court 2. Doesn't have anything to do with that individual.
I understand. Is this the same one that I guess you were described as being in a pissing contest with her?
If that was characterized, it was done by somebody else.
Well, yeah, that's how it works. Other people talk, and then...
I don't know who that individual was. It's probably a county commissioner from Precinct 3, maybe?
Kevin Wolf.
Kevin Wolf.
So you did know who it was?
Well, because it's right in that article right there. But I'm telling you, these people don't have any idea what's going on out there. They can say whatever. That's another elected official, just like I told you. Every elected official gets to say whatever they want, however they want. Kevin Wolf did not exchange one word with me about any of this situation.
I 100% agree that elected officials talking about other elected officials have no idea what they're talking about. I agree with that 100%. Your Honor, may I post the witness?
Yes.
We have our exhibit next in order.
Very well.
Very well. Thank you. Your Honor, I haven't had an opportunity to show this witness.
This, I do need to authenticate it with him if that's okay. This video.
Can you do it at a break and keep going?
Well,
So what you said was, I guess the time that the metal detector was not there was 24 to 36 hours? Is that correct?
The incident, I guess, from beginning to end, when it, you might say got hot, was 24 to 36 hours. The metal detector was gone for several hours. I couldn't tell you exactly how many.
Okay, so several hours.
Right. It wasn't 24, 36.
Understood. All right, I mean, at this point, I'm kind of in.
Okay.
So, would you like to take a break and do that?
Yeah, let's take a break so that you can show them the video that you want him to take a look at. We're off the record. Yes.
I'm showing you this marked for identification as Defendant's Exhibit 32. You see Defense Exhibit 32?
Is 31 the DVD?
31 is the DVD that I'll be, once it ejects, I'll be playing or offering.
Okay.
Do you recognize that email?
Yes.
And that's because that was an email that was sent from Mary Quinones, who is the purchasing agent for Bexar County. It was sent to Ruby Ng, who is at Blue Armor, but you were CC'd on that email and then replied to it.
Correct.
And
That's what it looks like.
this email has to do with the security arrangements from the purchasing agent to Ruby Ng with Blue Armor Security and the dates that would start.
Yes.
Your Honor, we don't have 32.
Did you say no objection?
Yes, Your Honor.
32, is that good?
And I'll just publish to the court. But what you read there was that the arrangements were made to have a guard from Blue Armor Security there on January 22nd, 2018.
Correct.
In that email.
Correct.
I approached you before with Defense Exhibit 31, which was a video that we got to view, and you admit and agree that the video that we saw, that was a video of you at Precinct 2, at the entrance to Precinct 2 with Bexar County Sheriff's deputies and with Bexar County Deputy Constables.
Yes, sir.
All right. And you know that this fairly accurately depicts the interactions that you had with them at that time.
Yes, sir.
Your Honor, at this time we'll offer Defense Exhibit 31.
How long is it? I only saw a snippet.
I mean, I can just play that snippet until he's off the camera.
Okay.
I think it's total of 2 minutes, but
So, and will you prepare just
Sure.
redacted? Okay.
A 31A.
Yeah. I have no objection if it's just the part where the witness is on it.
Is it? What is it?
this is 30. Oh, it's a video of an interaction between Judge Vasquez and the Bexar County Sheriffs and the Deputy Constable Lieutenant Minor. And
Right, so it's what she's agreeing to, which is just his.
as long as, so at some point he moves off the screen and the video stays on the deputies and the sheriffs, and I can.
So I would prefer that it's just, I agree to allow its admission when the witness is a participant in the video.
Yeah, that's fair, because.
So we'll have to do another version of it, I guess.
All right, 31 is admitted for the appellate record. 31A is admitted for my consideration.
Yes, Your
31A will be the redacted.
Yes, Your Honor. At this time, in 31, I will only play the part that's going to be not redacted. Judge, can you see?
Yes.
What about you, Judge?
Yeah, I can
I can.
Okay.
Fine, you're fine.
I get it. Does this computer have DLC?
Yes,
Does it?
Right, I ran this issue before.
it does. Just minimize that.
want to stop it at this point. Judge Vasquez, you would agree that on the right side of the screen there, that's you?
Yes.
And these are sheriff's deputies that you called to come in and do security on the door?
I don't know that I specifically called those deputies, or if I called them, or if it came from Commissioner's Court, Ms. Ng. I'm not sure where that came from. It could have been, yes.
Okay. And the metal detectors are there at the door, right?
Correct.
And then the deputy constable is there at the door working the security at the door.
That's what it appears.
Now, that's Lieutenant Minor there explaining to you that he's there and he's working security there, right?
I didn't quite catch that, so I don't know. That could very well be, yes.
I'm here. It's not your building. You don't know anything here. Don't talk to me. You don't talk to me. I can hear that. Yeah, it's first.
And I would just note for the court's benefit that Lieutenant Minor, who is working security, is wearing a polo and not a uniform. And that would be where we would redact the rest off of that when Judge Vasquez leaves the area. But Judge Vasquez, you saw yourself there telling Lieutenant Minor, it's not your building, don't talk to him, right?
Correct.
Okay. So when we talked about whether or not you had raised your voice or you had been unprofessional with the deputy constables, you have. That's true that you have done that.
I would consider that stern, and when we talked about this before, I was referring to inside of the courtroom, right? Now, we're outside here in a completely different environment, and when I say those words to him, that's an accurate statement. It's not my building, it's not their building, it's the county's building.
I understand,
right?
But it's his responsibility as one of the deputy constables for precinct 2 to do the security at the door.
That has not ever been ratified by anybody at the county. And that is an ongoing issue, by the way.
Let me ask you this. The other JPs, do the constables in the other JP precincts do security at the door?
I am not aware of what the security is at the other JPs.
Have you ever been to another JP court?
Yes, I have.
Well, I mean, did you see constables there from that precinct doing security there?
Counsel, what I'm trying to tell you is security has never been ratified, and it's an ongoing issue as to who controls what in these buildings. That's what we try to get the county to understand, right? Because it's a county building, and we have these agreements in place that we try to get things to run smoothly the way I was trying to do with the warrants. We have these agreements in place until you actually have to put an order out like we did to rescind the warrants at the door. It's the same thing with security. But first and foremost, I've got to have security. I've got to be safe in that building.
I understand. But what I'm saying is you had Lieutenant Minor at the door doing security with a metal detector. That's what we're seeing in this video, right?
I don't know when during that time period this is taken, because there was a lot of discussions previous to this that they were not doing security, and those are in emails.
Here's what I'm offering.
The constable said she couldn't do it anymore because of budget cuts.
Here's what I'm offering it to show.
Sure.
I'm offering it to show that you're in a situation where Lieutenant Minor is there and providing security, and you're yelling at him that it's not his building and don't talk to you. Now, when he addressed you, he said, "Judge, I'm here. Your Honor, I'm here. I'm here at the door. I'm here doing this." And you brought another agency in to do the security.
Well, there's a lot more going on than just these 53 seconds taken out of context in one day.
I get it, but when we go back to when we talked about a pissing match, you don't feel like you had any part to play in that?
A pissing match concerning what?
Concerning you're bringing in a new agency, a different agency, while she's got a deputy on the door doing security to go and take his spot in a building that she occupies as a law enforcement elected official.
No.
You don't-
Because it's not a pissing match if my security is at stake. I'm not going to walk into a building with all the defendants that we have, all the evictions that we have, and not have any type of security in the building. And the constable previous to this has already stated time and time again that she's not doing security. All she's going to do is provide a bailiff for the court. That's it.
What I'm saying is that you have Lieutenant Minor. What you see there is Lieutenant Minor there at the door, right?
What I see in those 53 seconds? Yes.
Okay. And Lieutenant Minor was a deputy constable at the time at Bear County Precinct 2.
I would assume.
And you obviously had some pretty ill feelings towards him because you're yelling at him that it's not his building and don't talk to you.
Those are not ill feelings. Those are trying to get control of security in a building that's being compromised.
Metal detectors are up. Yes?
The metal detector is there at that point. It's 53 seconds.
Right, but they're there. Right.
Yes, it's there. That's my metal detector.
Lieutenant, it's your metal detector.
It's the Justice Court's metal detector.
It's not his building, but it's your metal detector.
It came out of our budget.
Okay, I'm done, so can we move on to another topic of cross-examination?
Yes, I understand, Your Honor. I guess ultimately, the point I'm getting to is that you are still willing to tell this court, and the reason I'm talking about this is because I want her to be able to, I would like the court to be able to analyze your testimony based upon your feeling, your personal animus towards Michelle. Now, are you still willing to testify to this court that you did not have any ill will or bad personal feelings towards Michelle from the beginning of her term to the end?
No, these are professional interactions that we're having. Personally, I don't know who she is.
So your testimony to the court is that that was a professional interaction?
That's not with her, by the way.
I understand that with her deputy. That was a professional interaction.
That was a professional interaction letting them know they're not in, this is not their building, it's not my building, it's the county's building. So we got to quit playing these games leading up to this thing. There's a whole lot before this that took place that's not in that video. The major point is I was informed that they were no longer doing security. So when do I know that they're having security or not having security at the front door?
And that was because you had said that you wanted to hire Blue Armor Security to do the security.
It was because the constable had some positions cut, and she said she could no longer do that at the front door, only provide a bailiff. That was between her and the commissioner's court. But it caught the justice court in the crossfire because I've got to be protected and that court has to be protected. It was left unprotected.
And what we see in that video is that you were protected before the deputy sheriff came in there.
That I was protected?
Yes.
I never felt protected most of the tenure of her office there.
I understand. And that's based upon your personal feelings about it.
No, it's based upon their professional conduct.
So let's get to that. Like you thought, so you felt like, you know, those same deputies that were there then are there now with the new constable, Vasquez. You have a lot of the same people that are there. So do you feel protected now?
I feel protected right now. Yes, absolutely I do with Constable Vasquez. At the helm, we've had very many professional conversations. We iron out and we resolve any speed bumps that come along the way.
Do you like her?
Do I like her?
Yeah.
I don't know her personally either. Okay. Professionally, I think she is a very a smart person to interact with when it comes to the security of my court.
Right.
Right. And I have a bailiff there that stays with me for a while, and it's a very good way to practice so that communication between myself and the bailiff in the courtroom is top notch.
Okay, but
You know,
your
I feel safe.
All right, but your bailiff before was Moreno de la Cerda, right?
I had many other people that sometimes they themselves would identify as security, court security, because they didn't know whether they were a bailiff or not because of whatever training they were getting. You open up a whole lot of history here with individuals that didn't know exactly what they should be doing in a courtroom.
Between the two of us,
Sure.
you're opening up.
Sure, and I don't mind, yes. I mean, as far as De La Cerda, I think he has been in that courtroom. And he continues to be there from time to time. But I have one bailiff right now.
So I'm going to show you State's 86, which we've heard testimony is De La Cerda. Do you see that? What word do you see on there?
I see bailiff security.
All right, bailiff. Right?
Right.
You're arguing with me about it, and they're wearing a uniform that says bailiff on it.
That's not inside of a courtroom. I don't know where that picture was taken.
Oh, of course not. I'll pass it.
Your Honor, State's Exhibit 131 would be the next.
No, I think it's,
Oh, 130?
132. 131.
131?
yes, 131. How much more do we have?
I just said this one thing. I'm going to hand you what's marked as State's Exhibit 131. I pulled it out of State's Exhibit 130, which was the business records with the cover sheet of the business records affidavit. But I want to hand you what's marked as State's Exhibit 131. Can you describe what this is? Just without talking about the content per se, what is this?
This looks like an email that was sent from Mary Quinones, the purchasing agent for the county, to Constable Michelle Vela Barrientes and Judge Roberto Vasquez. Copy the court manager, Rita Burke, the former civil head, Ed Schreninger. It looks like Linda Dezon, Christopher Ayala, and Romaldo Moreno.
Okay. And what is the date on this?
The date on that email is Friday, January 19th, 2018.
And what is the subject matter?
Metal detector at JP Constable 2.
State would move to admit. State's Exhibit 131.
No objections.
State's 131 is admitted.
Can you read the portion from Mary Quinones to Michelle Vela and yourself? Could you just read the body of the information?
The metal detector at JP 2 Constable 2 was purchased August 8/12/2009 with JP Court Security Funds. It has been tagged and assigned to JP 2 for property. It should not leave the location it is in. If you have any questions, please let me know. Respectfully, Mary Quinones, CPBB Purchasing Agent.
And just one other question to be clear about the warrants. Clerks are allowed to do the window fees by law,
Yes.
and officers are not permitted to collect fees and fines by law unless there's an agreement in place.
Correct.
On that video, we we see Lieutenant Minor, and I know you might not know that that's him. Do you recall that day? I mean,
Not without having my memory refreshed like that.
Okay. And do you know whether or not Lieutenant Minor or any other person had been providing security at the front during that day?
No, I don't.
And what would precipitate having the Bexar County Sheriff's Office show up that day?
A lack of security and the court feeling in danger.
Okay. No other questions, Your Honor.
I guess the email that we just talked about from Mary Canonas, the reason that she was writing that email is because she was, I guess, confirming where the funds came from, because she needed to, I guess that needed to be confirmed. Who bought what?
I would assume so.
Right. And I mean, in 2009, were you with the JP then?
Actually not.
Right. And Michelle wasn't the constable, so the only way to do it is to look through the records and figure out who has responsibility for that medical check.
I would imagine, yes.
Right. And you said that, I guess when that email came through, the metal detector went back to where it was supposed to be.
I could not tell you right now the exact chronological order of how everything happened.
But we're talking about a matter of hours, is what you
Correct.
said. That
Correct.
It never left it never left the building. It just left the area that it was for.
My understanding was that it was wheeled into the constable's office. I did not verify that.
Okay. I don't have any further questions.
No other questions, Your Honor.
May he be excused?
Yes.
Thank you, Judge Vasquez.
We may need him subject to recall.
Well, you let me know, and he'll be subject to recall, but
Yes, sir.
I'm excusing him for today.
Yes, sir.
Judge, if I could ask just a courtesy, if I do get recalled, give me as much lead time as possible.
Absolutely.
Got to get coverage in the court.
Yes, absolutely.
Thank you. I'll try to be as quick as I can.
Call your next witness.
Thank you.
The next witness would be Constable Leticia Vasquez. Your Honor, do we still have a ruling on the admission?
Take the ruling up on
On these?
Says 128 and 129.
Your Honor, I don't have any problem with admitting those. We're talking about the bike. Yeah, I don't have any issue with admitting the bikers. The only issue I've talked about was as far as the summary goes, if at some point before this thing ends, or whatever ends, if I could just make sure that the summary is actually reflecting. As far as the admission of the exhibits, I believe that that's proper. With the consideration for the people, because there is date of birth, name, all this stuff.
Well, I've already said the personal information
Yes.
will not be published. So 128 is admitted. Those are the actual binders. I will give you until the end of today to give me your objection on 129, which is the summary.
Take down my business.
And just to be clear, 130 was marked but not admitted, correct?
Which one?
130?
Correct. It's marked and not admitted, and I haven't heard one.
You may proceed, Stan.
Thank you, Judge. Constable Vasquez, could you introduce yourself to the court and spell your last name for the court reporter?
Sure. I'm Leticia Vasquez. Last name is Vazquez. Constable at Precinct 2. I've been there 3 years.
When did you first assume the position of constable of Precinct 2?
I was sworn in and walked into the office on October the 9th, 2019.
And who was the constable before you?
Michelle Barrientes Vela.
And what did you do prior to being sworn in as Constable of Precinct 2?
I was a Bexar County deputy for 25 years.
And as a Bexar County deputy, where were you assigned?
I was in different areas. Started off at the jail for 5 years. I went to the courthouse, taught DARE. From DARE, we went to patrol. Was in patrol for 11 years, and then eventually went to community policing, which is where I was last at, which is a SCORE unit.
And when you were appointed and assumed the role of Constable of Precinct 2, what were your job duties and role in that position?
As the appointed?
Yes.
Well, I was the head of the office. I became the head of the office.
And what is the precinct's main duties?
Civil process.
And what civil process?
So serving papers, doing evictions, AG papers, any kind of subpoenas, plagius, anything like that. We've taken, we assumed some of the paperwork from the sheriff's office, so we've taken on a lot more work. So anything civil, anything that needs to be served by the judge, or actually any of the judges here too.
What about criminal investigations?
We do not. If we need to, we usually have to get assistance from either the DA's office or the sheriff's office.
So have you ever done a criminal investigation or assigned a criminal investigation involving felony offenses?
Sometimes officers come across stuff like that, and yes, we do. We prepare the package and present it to the DAs, yes.
And in that context, would it be something that an offense that's viewed by the officer?
Yes, yes. If he comes across something at a writ, or comes across something if he's traveling to serve papers or something, I mean, we're still peace officers and we have to react.
Explain to the judge, when you came into the facility at Precinct 2, could you talk about any outstanding debts that were associated with the precinct?
So when we walked in, it wasn't just the fiscal year that had just ended and started. There was credit cards. The credit cards that she had been locked, which they had two different credit cards. One's for traveling and one is for purchasing. And those credit cards had been frozen. So we didn't have those, and then everything else, there was a lot of stuff that was, there was balances that were due, uniforms, the stamp machine wasn't working because they had a balance that was due.
So let's talk about the stamp machine. What's the purpose of the stamp machine?
Well, there's a lot of papers that go out. We have paperwork that notices that need to go, like alternative services, that after one of my deputy constables goes and does, they try to service somebody, and if they don't, we always send a copy to that address. So we have to mail out all that stuff. So they need the stamp machine to process that alternative service.
And when you came into the facility, what was the condition of that stamp machine?
It wasn't working. It had a balance that was owed, and actually probably about maybe a week later I found a shelf that had envelopes full of paperwork that needed to be mailed out because they were lacking postage.
And so the fact that those letters and notices were not mailed out and the stamp machine was not working or functioning because of an outstanding balance, did that affect the operations of the constable office, Precinct 2?
Yeah, because that's one of the steps that needs to be followed. So some of that stuff had to be redone, had to be taken back to the court so the judge could reserve it.
And so the fact that there had been a backlog of paperwork, of civil process that had to be redone, did that negatively affect the operations of the Precinct 2 office?
Yes and no. I mean, the office, we continuously get papered. So it's just a turnover, constant turnover. So we just had to put it back into the cycle and continue moving forward.
So essentially, was there a delay from people getting served process?
Yes, of course there was a delay.
So you talked about two different cards. One card was for travel. What's that? What do you mean by that?
So for training, if the officers want to go do training, we have a card that's specifically used for training and traveling. We can only use that card for that. And during the budget, they give us so much money, whatever it is. And then the other one is for just purchasing. So we can only purchase certain things, but they give us like a guideline of what we can buy.
So let's talk about the first card, which is the travel card. You stated it was locked.
They were both locked. They were frozen.
Okay, so how did you get let's talk about the travel card first. How did you get it unfrozen?
Well, we had to jump through hoops and talk to everybody and let them know that it was a new administration, and they eventually released the funds to us.
Did that negatively affect the operations of the constable's office by having to jump through all those hoops?
Well, absolutely, because we couldn't send anybody to training at that time. So nobody could travel, no one could do any kind of training. And then also the purchasing credit card, that was another, we couldn't purchase anything with that stuff. Now, we have a list of stuff we can't buy anyway, so we had to be without some stuff.
So the purchasing card, that was also locked?
Yes, it was frozen.
Oh, frozen. And is that the same process to get that unfrozen?
Yes, yes.
What were some items that were purchased by that card by the previous administration?
Some desks, some tables. They were supposed to be desks, but they were tables. They were like entry tables with marble tops. They were supposedly purchased with those cards, and that's what they froze the account.
Based on the purchases of marble tables?
Because that kind of stuff like furniture and certain items have to be purchased with a purchase order, or there's a line in the budget that's for furniture and stuff, so they have to be done with a purchase order.
And so that's a process, I guess, to let the auditors know that you're going to purchase this item and get approval?
Yes.
And those marble tabletops had not gone through that process?
Right.
About how long did it take your office to unfreeze and be able to use the travel card and the purchasing card?
I don't remember how long.
Had there been outstanding warrants and other notices that had been not served?
Yes.
Could you describe the condition of the property room when you came into the facility?
The property room was in disarray. So there was stuff in the filing cabinets, like we've opened up a drawer in the property room, and there was a bunch of weapons in there. None of them were tagged with a report or any kind of case number. We had to physically run all the serial numbers and try and track down who the weapon belonged to or what case it belonged to, and try and match everything up. Then there's cases going back to like 1989 and that had never been worked on, or whether the case had been dismissed or to get rid of was the property needed to be destroyed or given back to the complainant or the suspect or whatever. So it was just not organized.
What about the printers at the facility? Did you have all the necessary items to be able to print things?
No. So the printers, they weren't just out of toner and ink. The cartridges were missing. They were completely taken out of some of the machines, so we couldn't even function without those.
Then how did you come to start functioning with them?
We just, in time, we just had to get organized and get with the right people to connect the right people with us so that we could buy the stuff that we needed to get these printers up and running. We had a projector in the training room that probably a year and a half later we realized it wasn't just broken, somebody had cut the wires up above the ceiling.
What about specifically body cam footage regarding the arrest of Leo Moreno. Did you come to locate that?
Eventually we did.
How?
So if you were to go to the office, there's a bunch of little closets, there's a bunch of storage rooms and stuff, and I eventually, we were going slowly and slowly through each room and trying to organize everything, and eventually we found the body cam. I contacted the trooper, I keep forgetting his name, the ranger, the DPS. Freeman. When we found that the body cams, we contacted him to make sure it was okay for us to. We contacted him to make sure. Can we touch them? Do you want us to look at them? We don't know what's on them. We don't know if it's anything that you can use. And he gave us permission. And once we realized what was on there, we forwarded all that information to him.
And was one of those body cams the body cam of Deputy Castañon, which had the arrest of Leo Moreno?
Yes, sir.
What about toilet paper in the bathroom?
So I don't know why. I guess.
Relevance as far as toilet paper in the bathroom.
They hadn't paid the bills, so the employees had to bring their own toilet paper to the restroom.
And you're saying that's the...
So it was the upkeep of the facility, and she had stopped paying bills at certain locations, including what I'll list also is uniform places that had outstanding bills, so the constable had to pay all those bills in order to start giving the services back at the facility.
I'm sorry, are you saying that each constable pays their own bills, or the auditor pays the bills for the county?
The constable pays the bills.
Each constable pays the bills of their building?
I don't know about each constable.
So, but the toilet paper, isn't that provided by facilities? There's the maintenance crew and they supply that stuff. So I'm still trying to elicit what is the relevance of the toilet paper missing.
And she had not paid the company that provides that stuff for the facility.
Okay. At this point, it's sustained. Move along.
Spoke about uniform shops. Where do the constables and their deputies get to purchase their uniforms along with patches?
So there's several. There's Nardis, there's Sterling's, and there's Code Blue. And there was outstanding balances at each of them.
And who pays those balances? Or who's supposed to pay those balances?
We do. Each office is, we are given a budget, an amount, and we're responsible for putting uniforms on each officer, or if we're going to buy patches or whatever, we order them through them, and we have a certain amount of money that we have to spend per year.
And as a part of your budget, you personally, through your purchasing card, are you supposed to go get it? How's that?
It's part of the budget, and we do. It's set up with purchase orders and stuff. We do not use a credit card for that. There's only certain things we can use the purchasing credit card for.
And were there some outstanding bills that had not been paid to different uniform shops?
Yes.
About how many?
All three of them.
And what were those amounts?
I don't recall.
Do you have an estimate of what those amounts were?
I don't. I'd be guessing. I'm sorry.
Ask the witness, Judge.
So, when you talk about, I just, Constable, I'm not even Jason Constable, we haven't met before.
No, sir.
I'm planning on staying out of precinct 2 for a while, though, but that's not your fault. I want to talk about
you're talking about the cars frozen, and I'm trying to understand. They were frozen by Bexar County?
They were frozen by Bexar County.
Right.
So, yes.
So Bexar County, I mean, you were there at the time that, I guess, you took office, was it October 9th?
Yes, sir.
2019. And obviously you thrown your hat in the ring when the Bexar County Commissioner's Court was trying to have Michelle removed.
Yes.
And I guess I say you threw your hat in the ring, but you put your name up for consideration and you were one of the people they considered.
I turned in an application, yes.
Right, so I guess, so you knew when you were coming in that Bexar County, and obviously it's all over the news, but the Bexar County Commissioner's Court and Nelson Wolf and some of the commissioners were very interested in trying to get Michelle out of office.
Did I hear about it? Yes. But did I know all the details? No.
Well, right, but I mean, you knew at some point that like, okay, I'm going to put my name in because they're trying to get her out.
Actually, no. I was out of town. I was in Orlando. I had no idea that the office had. I got called afterwards that the office had been raided and stuff like that.
Right.
I did not know what was going on that day.
Yeah, I understand, and I guess I'm not really talking about that day, but before you took office, you knew and understood that they were trying to get her out, and then and that's one of the reasons that you said, well, I'll put my name in to be constable.
No, because she did not. At that time, she was still the constable and was going to do another 15 months. So I did not know that all this was going to happen.
I understand, but I guess, and it's not your fault.
And I wasn't running for constable at that time. In fact, I was going to retire in 2 months, and I was going to be gone. I was going to be gone.
Yes, ma'am. And I'm not really. This isn't the part where I'm saying that you're doing anything wrong. I'm really just trying to establish your knowledge about the relationship between Michelle and the Bexar County Commissioner's Court at this time. That's what I'm trying to do. And I'm centering down on the fact that you must have known, in order to say, hey, I would like to replace her, you must have known that they were trying to get rid of her at some point.
I don't know about getting rid of her, but I know that they had an opening to fill because of what was said on the media.
Right, they resigned to run.
Right. Yes.
Sure. And I guess my point being is that the way that it was presented on direct kind of sounded to me, and I'm not saying you intended to, but the way it sounded was like they were frozen by like the card issuers or the bank or something. But it was frozen by Bexar County.
Yes, whoever controls those cards, it was frozen, I think, way before. Even before that even started. Even before that end of September, when that day that the Rangers went in there, I think those cards were already frozen.
Right. But they were frozen after Michelle and her deputies appeared at the Commissioner's Court, and she pointed out Nelson Wolf and everybody else on the thing and said, this is what y'all are doing wrong.
Objection, calls for speculation.
Well, I mean, she's the
Lack
constable.
personal knowledge of that.
She testified that it was frozen before this incident, before she became constable.
Right.
So she's already going before the time of constable about when they were frozen. So
If she knows, she can ask.
And actually, I don't know, because I wasn't following what the Constable Precinct 2 was doing at that time.
I understand. But you did say, well, I know that the cards were frozen before September.
Right, because I asked some of the employees in that office, is it because I know at every fiscal year, I always say it wrong, it starts all over.
Sure.
So for a time period, they freeze those cards. So you cannot, we have, I think, the end of August till a certain time to be able to use, we cannot use the cards. So I was thinking for a while that they were frozen because of that time period. And that's when I started asking questions. Are they releasing the funds? No, they're frozen for this reason.
Sure, and I guess my point is that you have a commissioner's court that is obviously hostile towards Michelle, and they have frozen her ability to pay on those cards.
And I wasn't paying attention to any of that.
I understand, and so, but because you testified about the cards being frozen, I want to kind of get a little more context to why. You would agree that it's not, well, let me just ask. because you mentioned the I guess the tables that I guess were like furniture. Did you know they were bought at a secondhand furniture store?
Yes.
Okay, so you knew that they weren't bought brand new, that they were bought used.
Yes.
Okay, and in fact, you said that they were, the purpose of the purchase was supposed to be for desks.
Yes. But even though they were bought there, they still needed a purchase order.
I understand. May I approach the witness?
Yes.
Constable.
Yes, sir.
I'm showing you a photograph, and that's Defendant's Exhibit 33.
Yes.
Do you recognize that as a photograph of the interior of what is now your office? Not your personal office, but the office that you're in charge of.
Yes.
And do you recognize that marble table there in Defense Exhibit 33?
Yes.
And that's one of the marble. That's one of the things that you were.
Those are the tables.
Yeah.
Or the desks.
Defense Office Defense 33. Okay. Your Honor, may I publish?
Defense 33, yes.
Yeah. I'm sorry. Was it admitted?
Yes, sir.
Okay. Thank you, Your Honor. Yeah. Is it on? Oh. Okay. So, Constable, in Defense 33, which I just showed you and has been admitted now, this is, I guess, like the marble table bought at the secondhand store that we were discussing.
Yes, sir.
And as you can see, at this time, when the picture was taken, it's being used as a desk.
Yes.
Okay. Now, Constable, I want to ask you about Exhibits 34 and 35. Now, do you recognize these as an office that's contained within Precinct 2 Constable's office?
I don't know what this is because it's too small.
Okay.
I'm assuming that is.
Well, I guess
yes.
I guess if you look at the tag there, that 50.
Oh, I got you. Okay.
So that 50 is just a close-up of what you see right here.
I mean, I guess it was in there. I recognize the carpet
Okay.
and the paint.
You don't recognize anything else about that?
I don't recognize anything else. I don't know which. I'm sure that was in one of the offices, but it don't look like that anymore.
Okay. I want to talk about
it was a little, I guess, confusing to me. That's probably because I wasn't following well. But it said, well, you said something about how the body cam, the body cam that you saw, or when you notified Ranger Freeman, you said you were looking through stuff systematically, but I didn't catch exactly where that was found.
It was found. So if you go to the office, there's a long hallway, and there's a bunch of little closets. And inside those closets, there was a bunch of stuff stored. And as we were cleaning stuff out, we found the body cams.
Okay. Did you find body cams of other things that weren't related to the arrest of Moreno?
Oh, I'm sure there was other stuff on there. Yes.
Like, were they in, like, what kind of container are we talking about?
I think it was in a box. I don't know.
Okay. So it was in some type of box that was in a storage room or somewhere.
So was I physically cleaning everything?
Right.
Sometimes yes and sometimes no. So I would go in there and say, okay, you know what, all this stuff needs to be cleaned up. And then I would delegate someone to do it.
Sure. And I guess what I'm trying to figure out is when it was found, were you made aware of it at the time that there were body cams that were found, or was it taken from the place that it was found and like brought to your office?
No, they brought me to the room and they said, what about this? And that's when we went in there and we figured out that was the body cams. And then we, Chief Horton, grabbed them and we contacted Ranger Freeman and we asked him for direction. Do you want us to look and see what it is, or do you want us to just send you the cameras? Because we didn't want to tamper it.
How did you know that they were body cams?
Well, I was with the sheriff's office. I know what body cams look like.
No, I mean, I guess were they the actual body cams?
Yes, it was a little body cam.
I see. So it wasn't like a disc that had a video.
No. It was the actual body cam.
Okay.
So we didn't know if it had been downloaded or not. We didn't know what was on there.
I understand. Okay, so you found a box and it had body cams in it.
Yes, there was cameras in it.
And then you downloaded it and the body cams had whatever it had on it.
Right.
Including, I guess, what you're saying was the arrest of Moreno.
Correct.
So the fact that you could see the arrest of Moreno meant that nobody went in and tried to erase it and nobody took the body cams with them.
No one touched those cameras but my chief.
Well, I mean, I guess before you came into office, the fact that they were there meant that nobody tried to destroy them?
No.
Nobody tried to erase it?
No, because they were in this one little closet towards the front of the office. And when I got there, I think everybody was, I don't want to say afraid, but I guess they were afraid to wander around the office, so they pretty much stayed in the back and were out of the field doing their work.
Sure. You said it's kind of at the front of the office. Was it in like a common area or?
No, it's locked behind. It was locked in the door. I guess I used to use them as holding cells a long time ago for juveniles. That's what I've been told.
I see.
So now there's just storage. They use them for the security cameras. One was used for the radios. One has a safe in it. Another one was used for a refrigerator and a microwave. So they were used for different things.
Sure. So I guess was there only one body cam found, or were there multiple body cams found?
I want to say it was 3 or 4 only.
Okay, like 3 to 4 different cameras.
Yes.
Okay. And
Trust the witness.
Yes.
Constable, I'm showing you what's been marked as Defense Exhibit 36 for identification purposes. Could you tell me about, I guess first of all, you'd agree this is an email?
Yes.
Email communication. And the date is October 1st, 2019.
Okay.
And that's what you see reflected on the document.
Yes.
Now, just to orient us, you came into office on what day?
October the 9th.
And you would agree that that email is Constable Vela begging for the purchasing to pay for the bills at the constable's office to Bexar County. What-
Maybe so, but I wouldn't have known anything about this.
Hang on, Constable. Objection to hearsay, please.
Objection to hearsay, it's a statement from the defendant that he's trying to admit or trying to elicit.
In Your Honor, I would,
That's not evidence also.
Response?
if I may respond to it, because they had Constable, sit back a little bit, because they had Constable Vasquez testify that these bills weren't being paid, and they implied that it was Michelle, or it was her fault that was going on. But 9 days before the constable sworn in, I have an email with Michelle begging the auditors to pay the bills and saying that, like, none of this stuff is getting paid. The way the state has presented it is they have implied that the reason it wasn't paid was because of Constable Vela's bad management. But what we are trying to show, in fact, was that the situation with the Commissioner's Court had gotten to such a point that they were cutting off all the funding for her office. And because of that, she is begging them to pay the bills, and they won't. And that's why it just goes to explain why she came into the financial situation that she came into.
She came into the financial situation, she didn't do the purchase order, correct? She was going around just buying stuff.
Well, so I guess that's their argument that they've been trying to
But
make.
that's not what you said on direct. On direct, you made it seem she didn't pay the bills. That's why I asked you. Is she responsible for paying the bills, or does someone else pay the bills?
And so we just asked in the interest of fairness.
That's the reason why the card was cut off, and that's what I think that.
You didn't say that. Nobody said that so far. You just said they were frozen, they were cut off, they couldn't go to training, they couldn't buy basic supplies, they couldn't. That's why I asked you, whose responsibility is it to pay the bills, and when did it happen?
Constable Vasquez cleared that up and said you have to go through the process of purchasing orders.
All right, the objection to hearsay is overruled.
And Your Honor, we just offered the email for the court's consideration on that basis to clear up, I guess, that issue that had happened on direct examination.
Okay.
Can we see it?
Oh, sorry.
ready?
No, Judge. No. Almost. About a minute and a half, please. So I guess my question is this part of the email chain, or is this the only email between these two? At that point, the state would optional complaints with the entire email chain be entered.
I think it's what we have. I mean, I don't have anything else that's directly related to what they're talking about.
But then within the document, Judge, the state would object. I know that the court overruled my hearsay objection, but within the document, each, for example, there's a statement here that says, I have maintained this office at times with my personal funds, which comes from the defendant. The state would object to that statement within the email.
Why don't you
itself.
redact what you don't want me to take a look at? I am just interested in her request to the county to pay bills. But there's two different things that are going on here. You want to make it seem like she didn't pay the bills. And really what I'm hearing is she didn't go through the proper process to purchase equipment, because there is a process. That doesn't involve payment. It just involves go through this process. If I want to get a desk, I need to go through a process. So that's different than not paying bills, because I was surprised to hear that any constable would be required to pay bills for their building. Like, I just never heard that before. So can we just clear that up? That's all I'm interested in.
Okay, and the state will clear it up and redirect.
If you can ask the witness to help me clarify that, that would be great.
So, but at
The
that,
state will in redirect it. I know that I'm not going to interrupt Mr. Goss's.
I mean, I can cross her. I mean, I
Yes,
can ask
please
the
clear that
question.
up.
so to answer the question as far as the toilet paper issue, it was a different cleaning company. And like the cleaning company we have now, they provide the toilet paper. So it depends on who they have a contract with. Everybody's different. I mean, the county changes people all the time, and sometimes they offer, well, we'll provide all the cleaning supplies, toilet paper, and I believe the one before, I don't know what was happening, but I know that there was no cleaning supplies, no toilet paper, so she was having to go buy toilet paper for the office because they would not release funds to her.
The constable was.
Yes.
Yeah, and you know that
Yes.
she was.
Yes,
She was
that's
using her
what
personal funds.
the employees told me. That's her staff told me that was there.
So, and I guess, because I know that she was, and we've kind of talked about that before, it's like, so it sounds like what the judge is really wanting to know, I think, is you as the constable, are you going out and you, like for stamps, are you going out and purchasing stamps?
We have a budget to buy all that stuff, so it is my responsibility to make sure that the stamp machine is paid.
Sure.
So yes, we do pay those bills. It's in the budget.
Can we maybe, and maybe I just want to clarify, do you take your constable credit card and run it in the
No,
stamp machine?
it's part of the budget.
Okay, so what you mean by part of the budget is you make a request to accounts payable or the auditor.
Right. We make arrangements to pay. I don't know, like certain licenses that we have to pay. That we're responsible to pay.
So I guess ultimately.
And we get bills at the office and we pay them.
And so ultimately, if you were talking about what you're talking about with purchasing, is that you have a purchase order that you fill out, making the request, and then Bear County itself is actually writing the checks to these businesses.
Correct.
And it comes out of your budget.
Yes.
Okay.
Because they oversee everything that we buy. I can't just go buy, I don't know, something crazy.
So if this was a move, you don't know when you're testifying that, okay, these cards are frozen. If this was a move by the county commissioners to cut her off because they don't like her, you don't know if that.
I do not know that. I just know that the cards were frozen from any purchases
And if they're
because of that.
If they're like, forget you buy your own toilet paper, constable, we're not going to allow you to get any.
I do not know that.
Okay, but you do know she was buying the toilet paper out of her own money.
I know that she would buy that toilet paper. Well, she needed to. She had to.
She had to.
Yes, that's something you have to get.
So instead of a story about how, oh, terrible constable, this is actually a story about a constable who was not getting the money from Bear County, so she went with her own funds to make sure there was toilet paper in the back.
Because the cards were frozen because she didn't use a purchase order to buy those desks.
And that's what your understanding is.
That's what I was told.
Understood. The two cards that you talked about was you said one card. Oh, and Your Honor, I'll still offer 36.
One for travel, one for purchasing. Is there more?
State has no objection to the admission of that.
36 a minute.
Yes, what happened to 34 and 35? Because you marked them.
I marked
But you
them, decided not to admit them, but I'll keep them with the court.
But what were they, photos?
Yeah, they were photographs of a desk and the constable's. Now Constable Vasquez's office, but not at
Yes,
the time.
yes, I understand.
So, right, one for purchasing. A credit card for purchasing. And that's,
For certain items.
okay, and so what were those items?
I was afraid you were going to ask me that because I don't know. I asked my captain, can I buy this with this card? And he'll tell me yes or no.
Okay.
There's certain things, there's a list of things we can buy. We can't just go into, it's like for emergency things that we can buy with that. I can't go buy anything that we can get, that we purchase with a purchase order, we cannot use a credit card for.
Sure. I guess, can you give an example of things you might have bought with that card?
Maybe if we needed a cable for the computer to connect a CD reader, something like that, we can go purchase something like that.
Okay.
But we can't go buy a printer
Okay.
because that's in a different, that we're budgeted to buy printers on a certain line.
And is there a purchase limit amount on your
Yes,
purchasing
I think
credit
at over $1,000 we have to get permission.
card? Okay. And you know if those tables were over $1,000?
I don't know the amount, but I'm sure they were because I think there was 10 of them.
From the secondhand store? you think
Yes,
there's
sir.
10 of them?
Yes.
Okay. Do you still have them? Use them in your office?
I have a couple.
And do they get good use in your office?
They're nice entry tables.
You use them as entry tables?
Mm-hmm.
And she was using them as desks
Yes.
for people to sit at and to work at?
Yes.
You said your captain that tells you, the one that actually knows, I guess, the one that you asked, like, kind of buy those things, is that De La Cerda that you're talking
Yes.
about? And he's the captain in your...
Yes.
Were you aware before you made him captain about his issues with TCOL and that he had been found by TCOL to have lied about his training?
I don't know anything about that. All I know is that his record was clear with TCOL. We have to follow the rules by TCOL. And if the officer, if there's a red flag that pops up when we bring him into the office, we're going to be alerted by TCOL.
I guess were you aware that TCOL had made a finding that he in fact had lied about his training?
Objection. Asking the answer.
I guess you said in the closet you had cases going back to, there was cases going back to 1989 in there?
In the property room.
The property.
There are cases that are sitting there. Evidence or whatever.
Right. And so that would mean that every constable since 1989 has neglected those cases. I guess that's it.
Yes. I mean, there are cases that are pending, or they haven't been closed out, or evidence that needs to be destroyed.
Were you able to go through all of that and figure all that out?
Yes.
And you know, you said a year and a half later on a projector, you said someone had cut the wires, but you have no idea.
I don't know who it was, no.
It could have been somebody in your own agency.
It
that
could have
did
been,
that.
yes.
Okay.
the marble entry tables, do they have drawers?
No.
And you said there were about 10 of them?
Yes.
So could you explain to the court about budget and what happens if you go over your budget?
Well, I don't go over my budget. I have a budget and I follow that budget.
And so what happens if you don't file purchase orders?
Well, I file purchase orders. I follow the rules. I don't know what happens if you don't.
And so, what's the purpose of a purchase order?
I guess that's what's required from the county. That's just one of the procedures that we do. We have to follow to purchase items so they can track it.
And could you explain to the court when you became constable of precinct 2 the condition and status of your TCOL portal?
The TCOL portal, for the training facility,
Yes.
it had, I guess it wasn't paid or it wasn't up and running, so we had to take care of that too.
And so what did that do, the fact that it was not up and running and say?
We couldn't do any training. Precinct 2 and 4 are training facilities, so we were not allowed to do any training until we got that reinstated.
And I may approach Judge, can see defense 35, was it 35, the email? So regarding the body-worn camera, Castañon and Leo Moreno's arrest, that actually did exist and was located at the precinct office?
Yes.
No further questions, Judge, or pass with me, sir.
I guess the TCOL portal that you're talking about, is that something that you pay with one of these 2 cards?
No.
Okay. Is that something that's paid by the county on your behalf?
Yes.
County budget?
Well, yes.
Okay. And you don't have any information about why it wasn't paid?
No, I do not.
Okay. So, were you aware that the person who is responsible, well, let me ask you this. Do you have clerks at your office now?
Do I have?
Clerks.
Yes.
Do your clerks have job duties and responsibilities such as communicating with the auditors or figuring out purchase orders or other things like that?
One of them does, yes.
Okay. And were you aware that Michelle's was Susan Tristan? You weren't aware of that?
I don't know, no.
And were you aware that Susan Tristan resigned the day after the FBI raid and left?
I did not know that.
And that was about, 3 or 4 weeks before you came into office. Yes, because that FBI raid was Late September, you came in October. But at the time, she was in a position, and you didn't know that, she was in a position as a person who dealt with the purchase orders and things, her clerk, resigned and took off to Seattle the day after the raid, and you weren't aware of that either.
No.
Now, an abrupt resignation by somebody who had been taking care of that would obviously cause, a few issues as far as trying to get all that straightened out, which what a responsibility.
Objection, argumentative, attorney testifying.
Well, I guess, let me ask you, like, if your clerk, if you had to do it, if they resigned abruptly, you would take some time to figure out what they were responsible for and what needed to be done.
Objection, calls for speculation, attorney testifying.
Overruled.
You can answer the question, if you understand.
You're asking me, ask me again.
Yeah, sure. You have a clerk that helps you with who does purchasing stuff or deals with the auditor's office
Right.
on purchasing orders and everything else. If they quit like one day, it just up and quit and left, it would take some time to figure out exactly where she was on her stuff, on her work, and she didn't give notice. She just quit that day. You'd have to kind of figure out what the process was.
Well, I'm going to answer it because my
Yeah.
office now,
Yes.
my clerks are cross-trained, so they can step into each other's roles. So if one left, the other one can do what the other one was doing. Because they take time off, so they have to cover for each other.
Sure. I guess
So
what I'm
everyone knows what they're doing.
I guess what I'm talking about is like an abrupt resignation. But I think from your perspective, your answer would be, look, I got cross-trained, so I would just rely on you.
Right. Because people take vacations, they take time off, so they have to know each other's work.
Understand. I'll pass it.
Who signs purchase orders?
I sign the purchase orders.
And why are you the one that signs purchase
I'm
orders?
the head of the office.
So you have your clerk sign purchase orders?
No. It all eventually comes to me.
And pass witness.
Nothing.
May she be excused?
She may.
Yes.
Thank you for your patience this morning. I appreciate it. Thank you.
Then the state has a few matters for the court.
Yes, can we take a break? Let's take a 15-minute break and then come back and handle those matters. the record.
So the first item, Judge, would be that the resign to run law was triggered on or about September 24th of 2019 when the defendant, who was then constable, announced that she was running for sheriff of Bexar County while holding the constable position. That is before the date of this email, which is dated October 1st of 2019. In order for the court to consider this email, the state would at this point like to read this email in order to put it into context of what's going on at the time.
It's in evidence.
Yes, and I think...
I already read it.
Okay.
Yeah, I
So,
read it.
for
And the
court-
auditor is saying, I've never heard of this. It's the first time anyone...
That the first time that she
Right.
has ever done this, yes. The first time that she's ever requested this, and that,
Right.
again, the state is putting in, again, I know that this is somewhat argument, that this is the first time that she has reached out to clear these accounts or to address payments and all that.
Okay, so
yeah.
I can take judicial notice that the resign to run was triggered on 9/24/22. What else?
I think it was on or about that date. I don't want to, I think it was either 23rd, 24th, or 25th around that date. But, and then additionally, Judge, I don't know if the court has ruled yet about the admissibility of the press conference, the defendant's statement at the execution of the search warrant, and then the other broadcast from KSAT that was about the delay of the arrest. Has been testimony that there was that the body cam of Deputy Castañon was located at the precinct by Constable Vasquez, and obviously that body cam has been admitted into evidence. Off the top of my head, Judge, I have to go back and look at my notes, but on one of those statements, I believe the constable states in her statement that they do not have body cams, which the state would, of course.
So let's start with 117, which is what you purport to be the KSAT broadcast.
Yes, Judge.
I understand there's no statements of the defendant, Mr. Ross?
None except for a statement that Dylan Collier said was sent an email to him, and then they put up words. She says, I think I'm not going anywhere.
I'm inclined to sustain the objection to 117. And I'm inclined to get a redacted version of 118, the press conference with just the part of the constable. And then I think 119 is admissible. So do you have anything you want to add on based on those rulings? So 117 is out. 118, the full version is admitted for appellate purposes, but 118A will be a redacted version just with the constable's statements at the press conference.
Well, understood. And 118 was provided to us in discovery. However, 119 is not.
The Cansfied interview at her office, is that where she declared she's running?
No.
No, not yet, no.
Oh.
This is outside at the search warrant, at the execution of the search warrant. And she's giving an interview to Ken's 5 that's being recorded. And she's standing there with counsel. With prior counsel.
Right, no, it was. It wasn't provided to us. It wasn't noticed to us.
Was it provided to the defense?
No, not in discovery.
I've given you a chance to review it though. So you've reviewed it, what's the objection?
I've quickly reviewed it along with two other videos in the back office or in the jury room. The problem is that when we're not provided with things, we don't have the ability to rebut these things, whatever those things are. And so our objection is that it's trial by ambush by giving us these things and saying, oh, review them real quick, and not the court, but the prosecutor making it to where I have to review it one time go through and then try to figure out every possible way that I would rebut it, which
I sent it an email prior and said that it was the state's intent to use these broadcasts and that it would include the statement from the defendant.
it was. I mean, I was in Philadelphia with the mock trial team at the time, and but that's the thing. It's like this has been. I mean, it's years and terabytes of information that have come over to us, and then it's just one more thing. And
and they just have to have it.
It's not a custodial statement. It was a statement that was given to a new agency with her prior counsel there. It's been in the public domain for multiple years at this point. Again, the state did send it over and said that it was our intent to use that statement, and then of course to notify the court why I started looking for statements that were out in the public domain was to show that she had knowledge of the arrest and that she was still attempting, even after the arrest, after the allegations had been dismissed by the district attorney's office against the owner, I was still advocating that Joe Gonzalez, the elected district attorney, reconsider his position on that arrest, which shows that she had knowledge and that had some role in that arrest.
119 is admitted.
Objection is overruled.
Yes, objection is overruled. 119 is admitted. So go ahead and get me a redacted copy of 118, make it part of the record, and put it on with the evidence that's been admitted so far. So we have now gone through more than 30 witnesses since this case started. State, what else? Who else are you going to call besides the Mark Garcia that we have to figure out? Is that it? Okay, so let's talk about that. So as I understand the situation, there was a prior joint representation that occurred between your client and Mark Garcia in a federal case?
Well, she was being represented by Mr. Sanchez, and only she. Mark Garcia was brought into that at some point in time, and then yes, he was representing both of them on this issue, Moreno arrest and EEOC complaint.
I get that.
At that point, yes.
So, and the only way that I can try to get some clarity is if I offer a hypothetical. If David and I go rob a jewelry store, and I tell him, I'll drive the car, you hold the gun, and you rob the store. And these are communications that we're having.
Right.
Before we hire attorneys.
Right.
And then I want to turn on David. What stops me from testifying against him on what we did and what I know and what I saw?
Well,
and that's different than if David learns and I learn something together as part of a joint representation where I either admit, deny, explain, rebut anything that either of us did, and David wants to come or I want to go to court and I want to use that. Like, that would be prohibited. That is confidential client communication that one or both of us learned in that time frame when we were both jointly represented. But help me overcome that he and I can still talk about, or I can still go after him and say what we each did, what I saw, because then it's a he said, she said, right?
Sure. And so, are we on the record?
Yes.
Oh, okay. You want to be?
Yes.
Okay. Okay, so I think that the hypothetical is, I don't think that the court's hypothetical kind of deals with parties, people acting as parties, and then what happens, like, during the time of the commission of the office. I think the issue, our problem is that she has told her lawyer in confidential communications about this incident, about what she knew about it, about what she was doing. And now we have no guarantee, because her lawyer has now represented a person who is going to testify against her. We have no guarantee that the things that was proffered to the DA's office were things that were told to Mark by his lawyer that he got from the confidential client communication.
I get that. That violates all sorts of rules. I get that. But what stops me from testifying what I saw, what I did, what I claimed David did? What stops me from testifying?
Because what should stop is the fundamental fairness of the Sixth Amendment that says that she is entitled to conflict-free representation, and she is entitled to be able to, and so we're talking about public policy here, like the private things that she has told her lawyer about this incident. And so we're talking about EEOC Miranda. So
I understand. That's what I'm limited Garcia's testimony to.
But our issue is that that's the thing those are the things that he cannot talk about, because those are the things that were involved in his lawyers when he was representing her. And those are the things that would be covered under the attorney-client communication privilege that she has with her lawyer that she can not now know. And so due process, part of due process is the appearance of impropriety and the appearance of wrongdoing. And so we can't know that what he's testifying to about our communications that happened actually happened, or did his lawyer tell him to talk to them about that because he got specific things and information from her in the attorney-client privilege. And so the problem is now he has to violate everybody's attorney-client privilege in order to suss out, like, oh, this is what he knew and this is what I told him or didn't tell him about, about what I learned from when I was representing Michelle as her lawyer. And so the issue is that for her to put this man up there is a betrayal of her, and it would be kind of a court putting the imprimatur of lawfulness or fairness upon this betrayal. And so one of the reasons is just like, I'll give a hypothetical, which is the reason that they exclude evidence is not because the evidence isn't good or there's whatever else. It's because if there is wrongdoing to the point where it becomes a due process violation, then the exclusionary rule applies to say you can't do this. So the DA's office has told you, they've told the court, we knew this was an issue. We've known it was an issue for a long time. We've talked about it with appeals, and we've done all this other stuff. And we still entered into an agreement with him, with that attorney, knowing that that attorney had represented Michelle on those topics.
Well, but they also represented that the attorney, expressed there was a waiver of conflict or a consent, which probably would only be applicable to the federal case, not this case.
Well, and what I'm saying is that it's kind of like, everybody's rights are greater than hers. Is how they view it.
Yeah.
I'm not saying you do, but Mark's Sixth Amendment right to have his lawyer that he wants outweighs her right to have a lawyer that doesn't take another client and have that client testify against his former client.
Well, she has unconflicted counsel with you all, and my point in releasing the other attorneys is that he's entitled to unconflicted attorneys for his criminal case. So, there was just no way that could continue. So both of them, as it regards unconflicted attorneys, I think right now we're good. I'm just asking about, if he gets up here, you're going to object to privilege, right?
I think that because it cannot be taken, because we cannot know what Mark Garcia is saying out of his mouth did not come from his lawyer who got it from Michelle.
And how, if I prohibit him from going into anything that he learned during this joint representation, and he can only testify to what he saw, what he heard, any statements against interest, how does that not fix it?
Well, because to be perfectly honest, I understand that I may have a respect for the court's prohibitions, but I don't know that everybody does. I don't think Ranger Freeman did, and I think that he's about to find out. And I don't think that the jury all the time is able to disregard those things. And I don't know, and she doesn't know, and that's the point now, is that the court, by allowing him to testify on those specific issues, would be basically saying, you know what, you can always wonder, and if your attorney betrays you, if the attorney now is acting in Mark's interest, so he's giving Mark Garcia everything that he can give him that he learned from there. And you know, and I'm not saying anything personal about the attorneys, but what I'm saying is that...
I mean, I'm very concerned. There's actual law licenses that are on the line right now. I take this very seriously.
I agree, but I guess going back to the exclusionary part is that, you know, of all the people in here, I think that, you know, the state doesn't have constitutional right to confrontation. State doesn't have constitutional right to counsel of their choice in the Sixth Amendment. But it seems like what they want from this court is they say, I want to present all the evidence that I want. We don't care about her rights. We don't care if we're talking to a witness who has a lawyer in the room that represented her in this issue, and we're going to steamroll over that. So what I'm going back to is that's where the exclusionary rule comes in, is to say, look, y'all made that mess. They made the mess. They did with the attorneys. Because you knew of this situation and you went forward anyway and got a proffer from him and made the contract. I was telling Mr. Salinas that I think that Mr. Garcia could ask them to specifically perform on the contract if you denied him the ability to testify in this hearing, because they knew the situation existed at the time they signed the contract, and the fact that he can't testify, I think he can still hold them to dismiss all his cases. Because I think that, well, and here's my point though, so it's not necessarily, it would just be the court making the decision that, you know what, Michelle has the right not to wonder in this kind of case. With everything that's gone on, she has a right not to wonder if her attorney has fed this witness who is testifying against her, and I believe will testify falsely, honestly, just from the little bit that I've heard. So whatever that he's been fed or whatever, we always have to wonder and have to hope that the court's prohibition on it, while this guy's trying to save his life or save his not being a convicted felon or whatever else, that consideration that he has that they've been giving him is going to outweigh anything that you have to say, because he's got to say now what he promised. I don't know what the proffer is. I don't have it, but he's got to say it. And so whether or not that came before your prohibition, nobody was even asking this question, or maybe they were. I don't know, but nobody was considering it. And so it just feels to me like we're just stepping on her again and again and again and again and again, just to satisfy the state's urge to present every possible thing to this court. And I'm just saying that she does have constitutional rights and they don't. And so, for me, that's part of it. Now, Patrick has a much more eloquent legal argument. We're not going to be ready for that until tomorrow. If we could have the...
Yes, so Mark Garcia may show up tomorrow at 1 and say he's not going to go forward, he's not going to testify, I don't know what's going to happen. I'm just trying to elicit from both sides how, if at all, and what parameters would be set for Mark Garcia to testify, because I do have a lot of concerns about due process with regards to the joint representation, and that it happens to be about this official oppression charge regarding the arrest of Moreno. Like that was it, right? That was, along with other collateral matters, but that was pretty much the focus. So, state, are you prepared to try to help me work through this today, or you want to wait until tomorrow at 1? I'm not anticipating that we can get much done tomorrow at 1, except, find out where Mark Garcia is at and find out if any of you have any law that you want to present, and then even then. So if I don't allow Mark Garcia to testify at all, are you ready to proceed to punishment?
Yes.
And Your Honor, regarding all of this, I think your hypothetical is directly on point. We're talking about personal knowledge. Mark Garcia has this personal knowledge prior to any representation.
And then, state, you have to really think about it. I am the trier of fact. I have sat through this whole trial. What weight am I going to give his testimony when he's going to get a walk on everything? Are you really going to get the bang for your buck? I don't know. I don't know what the proffer is.
Well, and that's the point I was going to make, is that he is going to be testifying from personal knowledge, nothing that he may have gained from anybody else. But I will tell you that Mark Sanchez will testify in front of you and represent to you that he never had any communications with Michelle Vela in front of Mark Garcia, nor did he ever tell Mark Garcia anything that Michelle Vela may have told him. Additionally, the proffer will be from Mark Garcia's own words and personal knowledge. It's not about anything he can testify to from his own experience. So I think that that will not go into any purview of any confidential information that might have biased him in some way. Additionally,
I mean, you have to take that into consideration, defense, that if Mark Sanchez is going to come and testify, you need to talk to your client about it.
Well, and so I'll say the first thing is actually a mark in her favor, because if she were telling Mark Sanchez things in front of other Mark, then she's waived her privileges to those. But the first thing they said he was going to testify to is that she never had a conversation with her and him together. Only with her. Only private, confidential communication with the client. You know, and as to the second thing...
I just don't know why people do that.
As to the second thing, you know, I understand, and like I said, it's hard. Fellow attorney, it is what it is, but I represent her, so I'm not with him. The second issue is whether, if he came and told the court that he did do that and told Mark things that Michelle had told him, he'd be disbarred. And so he's never going to come testify to the court that he did anything other than I never, ever, ever.
but that doesn't mean he's lying.
I'm not saying it does, but what I'm saying is that it doesn't get over the appearance of impropriety, which is also a consideration, because that's the way justice runs, as we all know, is that it has to look fair as well as be fair. And if it doesn't look fair, the court can make determinations and decisions to make it look fair, which is, I'm sorry, you can't talk about that stuff. And if y'all had an issue with that, that should have been ironed out a long time ago. But they went full steam ahead on it and did a full proffer with the guy while he's being represented by somebody who represented Michelle.
And again, that proffer is going to be his personal knowledge, and you can see it on the face of the proffer when we complete it and get it to him. But also, I'd like to point out that we're working blind here in the essence that these kind of motions actually should be put in writing so that we know where the authority is, and we do not know. Apart from the one case he said, and by the way, that was an ineffective assistance of counsel case, so we do not believe it's applicable under these circumstances and facts. So I would really rather, before we have a hearing, have a written motion with cited authority so that we can properly prepare our response, so that we can do thorough research before we just have a hearing tomorrow at 1 o'clock. I would rather that come at a later time so we have sufficient time to prepare.
You know, I agree with that, but, you know, I also understand that, and I know the court understands that it's like I've been hit in the face with a new thing every day that I come in here by them, a new explosive allegation or a new explosive thing or whatever. And so it has been difficult to not only do the duties that I was expecting to come here to do with cross-examining people, but also to figure out, like, what are the legal wrinkles that are coming up because of the things that they're surprising me with.
Well, that happens on both sides, Your Honor.
I understand, but only one side has the constitutional rights that are involved in it, and the state does not. And so, you know, we agreed, I agree with Don, that we would need time to formulate this issue, but I think it's important. I think it's huge in that sense. We would need time to do that. So therefore, I'm hoping Patrick's still at the office, you know, and I'm hoping that he can, like, bang something out before then, but I do think we probably need more time as well to get something written and to have them respond. And have us respond to that.
By the time they have it written, we don't have time to look into the matter before 1 o'clock tomorrow. And in the meantime, we'll
Well,
find
there's some
out
meeting at 1 o'clock because we need to get an answer from Mark Garcia.
related to his representation.
Right.
Okay. And then that would be the only thing that we would be addressing at that time?
I just don't know where else I can put this. I mean, I have this week scheduled for this. I would have to probably tell you tomorrow.
situation as what was not created by Michelle. And I'm not saying the court is saying it was, but it goes back to our argument that sometimes they just don't get everything that they want. If they create the situation that causes these kind of issues.
All right, so take your calendars out. When do you get back, dude? When do you get back? You said you're out for 2 weeks. You get back on the 24th. When are you out, Jason?
I will be gone for a mock trial tournament from October 29th, which is a Saturday. So the 28th will be the last day I'll be present through November. I'm flying back November 7th. So I'm flying back November 7th, so the 8th will be the first day I'll be back and then able to work.
So can we work on the 24th and 25th of October?
The 24th and 25th, my co-counsel is in Mexico.
Your co-counsel may have to miss. Or do you want your co-counsel to be here when you're gone?
Well, I mean,
There's a lot of days in November that, there's, all my Fridays are taken. November 11th is a court holiday. I'm at a board meeting November 18th. November 25th is a court holiday. And you're not going to be back until the 7th. So November, there's no options. So we got to squeeze it in, the 24th and 25th. Because the outcome is either going to be Mark Garcia gets to testify for a limited purpose or not, and if not, you go straight into punishment. And in fact, what we could do is you can file your written objections and responses to me before the 24th. And that gives everyone at least 2.5 weeks to work on it.
understood. So what I cannot represent to the court is that I have no idea what this proffer is. I have no idea what I'm going to have to chase down based upon the proffer, what I'm going to have to check, what witnesses I'm going to try to find. It hasn't been created yet, and so it hasn't been given to me yet.
Can you give him a copy? Because I usually don't sign those. Those are usually just attached to a plea bargain agreement.
Copy of
The proffer, the plea bargain, the immunity agreement.
I have that. I have that here.
I thought that was the proffer was part of the agreement.
they already have that. It's the FBI transcript of the 4-hour interview. That they already have that, but if you'd like me to make another copy, you can. But yes, I can shoot him through my email a draft of the draft that you have attached for the actual immunity agreement.
Okay.
Hey, Your Honor, I think what I'm referring to is their obligations under 3914, and Brady now say that they need to give me they need to tell me what he told them and what they
Yes,
offered.
yesterday I said they were, and they
Yes.
offered to.
We have to
In
wait
writing.
until he gets new counsel.
Right, and so what I'm saying is that since I don't have that, and I just want to tell you that I don't have that, if I get it on the 7th, but then it's going to take me weeks, we can come and the court makes the decision on the 24th or 25th. I still may need time after that to cross-examine.
I wouldn't expect you to cross-examine him. If he's allowed to testify, we would reschedule that.
Okay.
I can't imagine that we could do all of that in 2 days.
Understood.
But we have to do something to get this moving. So I haven't heard enough to make me say he is going to be allowed to testify. I am inclined to not let him testify. But I'm giving both sides a chance to give me the law that I need to consider. I've done research over lunch, and that's where I'm at right now.
I didn't hear what you were saying. I couldn't hear not the negatives or the positive words that you were saying. You were saying you were inclined, I'm sorry.
So I'm inclined to not let him testify.
I understand. Thank you.
Is where I'm at right now. But I'm giving you an opportunity, both sides, to give me the law that I need to consider in order to see what, if anything, he can testify to. I think it would be very limited in scope. But what I am saying, Jason, is that I'm not expecting you to cross him. I'm just expecting that if I allow him to testify, he testifies. And we get as far as we can get in those 2 days.
I understand. And I'll have the witnesses ready for that day, our witnesses, so that if the answer is you can't testify, we'll start with our witnesses.
Yes.
And I won't need the time because I don't have to react or respond to it.
Yes.
I understand.
That's the backup plan. And do you understand, Don?
Let me clarify. So first and foremost, when does their written motion needs to be given to us? So we know exactly what it is they are objecting to and what authority they're utilizing.
Yes. So let's do Friday, this Friday, file whatever objection you have to Mark Garcia testifying. State, I'll give you a week, so to the 14th, you can file your response. And then hopefully I can have an answer to you after I have everything in writing so that we know exactly what we're doing on the 24th and 25th.
So coming into the 24th, we'll know whether or not Mark Garcia is testifying.
Yes.
So,
and you know, a lot of this might get answered tomorrow afternoon. He could show up and say, I want to rescind this agreement. I don't know the terms, so I don't know if he can.
So as soon as he does get new counsel and he does want to proceed, we will get the proffer prepared, but it'll be subject to he and his attorney's schedule, but we will push to have that done as soon as possible. But just to be clear, again, it's nothing new. It's the Moreno arrest leading to the aggravated perjury and the official oppression unlawful arrest.
I get that.
There's no new evidence, no new facts. We just want to let them know what he said about what occurred. There's nothing that changed in history, so to speak.
So at the same time that the defense is getting their written objection and you're responding, go ahead and give them, try to get them the proffer by the 14th as well.
Your Honor, my co-counsel addresses it for the record.
Your Honor, I would just like to clarify opposing counsel's statement that nothing new has been learned because prior to our
I didn't say nothing new was learned. I said
There's
has
no
occurred.
evidence.
I said whether it's occurred.
Prior to our lunch break, it was conveyed that there was new information and new facts that had been learned that were not learned from that 4-hour proffer from years ago.
I don't know if she said new information. She said there's a new interview. And so I told her, you're going to have to give them the substance of that interview in writing. That's what I said. Because that's what I heard. I don't know if I heard her wrong, but she said there was a new interview. So that I don't know if there's new information. I'm not going to, get in the middle of that.
What I'm stating is nothing new occurred in time because this is all happened before. What happened. We will get it all in a proffer, what he's going to testify to in his personal knowledge. But the hope is that if he does get a new attorney, that their schedules can accommodate, but we will push them very hard in that respect.
So defense written objection to Mark Garcia's testimony is due this Friday, October 7th. State's response is due October 14th. And I will have a decision before we reconvene on October 24th. So we're going to reconvene October 24th and October 25th, assuming that the double murder I have next week will be finished by then.
Your Honor, I'm sorry. I don't want to, it's not to antagonize the court, but ours is due in 2 days and they have 7 days to respond to it. I don't know, I just don't right now, because as the court knows, although I do appeals, I am not the expert, and I'm not the person that Michelle hired for the appellate issues at trial. She also has a different appellate lawyer who has been retained. And
Not Patrick?
Not Patrick. What we've done is in preparation for the motion for new trial and appeal, we have, as we think is best practice, had her go somewhere else to be able to grade us.
Well, that appellate attorney needs to come talk to me if he needs more time.
Yes, Your Honor. I don't know if he would even participate. This may not fall under his bailiwick as far as what his thing is, and so if not, it would be Patrick. And if it is Patrick, I just don't know what his schedule is. Would I have the opportunity, if he needs more time, to get his in to
He can come see
address
me.
the board? Thank you.
He can come see me.
Thank you.
But there's no question about the schedule, right? The 24th and 25th, we're going to come back here. I'm either going to let Mark testify, or if not, then we go forward with defense punishment. Right? It's your intent to rest if his testimony is not.
Well, we might have to call this a catalyst then.
Okay, have him available.
Okay, well, he's on standby, so.
I would have, we also have something to address with that.
We already testified.
He did, but if the court remembers, we made a very limited waiver of client confidentiality or client privilege, attorney-client privilege.
Well, I understand he's coming to testify about Exhibit 100, or the lack of videos or something. Isn't that what you all said?
It's about the business records affidavit, yes.
I believe that based on the memo the prosecution has provided us, I believe that they went and sat down with Les and asked them about client communications between him and her.
Okay, well, we can take that up on the 24th. Just have him ready if they're going to call him. That's not what I recall, but.
That's what I thought. That's what happened.
I mean, guys, if we don't get this moving, you all are going to be working Thanksgiving week, and I don't think anybody wants that. So when else can we reconvene that you're not out of town and it's not a court holiday, but a couple of days before Thanksgiving week or during Thanksgiving week? Like that, I don't see anywhere else. And then Dom is getting ready to retire, so we need to finish this.
Yes, Your Honor, I agree.
And I still have to deal with Mark tomorrow, so let's reconvene at 1. You know what? I told him 1, but it's going to be more like 1:30. I have a lot of opposed sentencing hearings tomorrow. So 1:30, please.
Your Honor, my client needs to be present as well.
Yes, please.
Okay.
Do I have all the exhibits?
I owe the court a redacted copy.